Committee will come to order. The clerk will call the roll.
Mr. Chair, you have a quorum.
Thank you. The first thing we'll do is to hear the report of the Criminal Law Subcommittee, Senator Serval. We'll not take any new testimony.
Thank you, Mr. Chairman. The first bill on the docket is Senate Bill 41. I'd like to skip that. Senate Bill is actually 41 and 126. They got rolled in, so I'd skip to Senate Bill 134 first. So Senate Bill 134, Mr. Chairman, was your bill. That bill raises the maximum age for delinquency from 18 to 21 years old. The amendments to the bill that we did in committee basically make the juvenile expungement provisions applicable to underage persons and then add a delayed enactment clause to January 1 of 2024.
Is there a motion to adopt the amendments? Go ahead.
Sorry. Yeah, and I would move to adopt the substitute.
All in favor of the motion to adopt the substitute, say aye.
Aye.
Aye. All opposed, no. Motion carries.
Having said that, Mr. Chairman, the subcommittee recommended reporting and referring to finance on a 5-2 vote. I would also just note for the committee, this is the first bill ever where JLARC has prepared a racial impact statement, which is kind of interesting if you want to go read that.
Yeah.
I'll second the motion.
All right. All in favor of the motion to report the substitute as amended and refer to finance. All in favor, vote aye. All opposed, no.
Ayes 9, no 0.
Thank you, Mr. Chairman. The next bill on our docket was your bill, Senate Bill 137. This bill has to do with requiring judges to provide a clear explanation of a deviation from sentencing guidelines. And it makes it clear that a failure to provide a written explanation constitutes reversible error. I believe there's a substitute, so I'd move the committee substitute.
All in favor of the substitute, vote aye.
Aye.
All opposed, no.
Thank you, Mr. Chairman. With that amendment, the subcommittee recommended reporting 5-0, and I would move. Although we need to have a substitute in front of us. I think there was actually some new language that Mr. Qualiato and Mr. Benjamin were working on.
Okay. Yeah, this is language that they worked on over the weekend, I believe. Let's take a look at the language.
That's correct, Mr. Chairman. Mr. Chairman, note for the committee, the new language in the substitute is on lines 39 through 44.
Okay, any explanation of the substitute?
Now, Mr. Chairman, as I said, the subcommittee's concern was that they want to make sure that the trial courts were maximally incentivized to provide a written explanation for this deviation from sentencing guidelines. And there was a concern that the Court of Appeals might not find it was reversible error if they didn't note it. They might resort to the harmless error rule. So we wanted to make it clear that the failure to provide a written explanation of a deviation would constitute the grounds for reversing a sentencing decision.
Okay. Any discussion?
Mr. Chairman,
Senator Aubergine.
isn't that a matter within the discretion of the court anyway, reversible only for clear error?
Mr. Chairman, this
Abuse of discretion and clear error.
Mr. Chairman, responding to right now, there's really no law about this, and what we were seeking to do is sort of mirror what happens in child custody cases, which is when the Court of Appeals has held that, well, the language isn't the same, but the effect is the same. In child custody cases, if a court fails to explain its analysis under the 13 different factors for custody, the Court of Appeals has held that it's reversed and they send it back for an explanation, and then it goes. And we were trying to incentivize the same type of ruling, but absent a specific directive in the code, we don't know what the Court of Appeals would do.
Yeah, Senator Aubergine.
Recollections
can't hear
For
you.
child custody, that requirement is because it's statutorily set forth. So anyway,
Mr. Chairman, I just stated, gentlemen, it is statutorily set forth, but there's lots of things in the code that the Court of Appeals finds are harmless error, unless we tell them they're not. And that was the concern. I don't know, Mr. Benjamin.
Yeah, Senator Benjamin, Steve Benjamin, counsel.
I don't think I can add to this discussion. But to answer a previous question, currently, no aspect of a criminal sentence is reviewable on appeal, so long as it's within the statutory sentencing range.
Okay. The judges have broad discretion as it is, even though we have guidelines. All right, is there any discussion?
Mr. Chairman, as I said, the subcommittee recommended reporting 5-0, and I would so move. I'm sorry, reporting and re-referring to finance, and I would so move.
Okay. Is there a second? All right, check.
I'm sorry, Mr. Chairman, this does not need to go to finance, so this would just be report.
Doesn't need to go to finance. Okay. All in favor of the motion to report the substitute, vote aye. All opposed, no.
Ayes 9, noes 4.
9-4. Next,
Mr. Chairman, next bill on the docket is Senate Bill 198. This was Senator Mason's bill, and what he's trying to do here is sort of deal with people who have competency issues in court. And basically, right now, under current law, you're not allowed to dispose of a person's case in any fashion until their competency has been restored. And the way this bill is written, you could basically put somebody, if somebody's charged with the agreement of the accused counsel and the Commonwealth, the person could be put in a civil commitment proceeding, and then their charge is dismissed, instead of making them go to like Western or Eastern State, get restored, and then come back. And so it's, I think, a kinder, gentler way of dealing with somebody who's incompetent. The charge would have to be dismissed.
okay.
I'm sorry, there's a substitute, so I'd move the committee substitute.
All in favor of the substitute, vote aye.
Aye.
All opposed, no. Motion carries.
Thank you. And having said that, the subcommittee recommended reporting with this, and does it have to go to finance?
Yes.
Okay, reporting and referring to finance, we recommended that on a 7-0 vote.
Got a motion, is there a second? All in favor of the motion to report the substitute and re-refer to finance, vote aye.
Ayes 14, no 0.
14-0. All right, Senator Searle.
Thank you, Mr. Chairman. Senate Bill 249, there's a substitute for that. I'd move the committee substitute.
All in favor of the substitute, vote, say aye. All
Aye.
opposed, no. Substitute's adopted.
Thank you, Mr. Chairman. Senate Bill 249 is my legislation. This has to do with sort of modernizing, updating, and expanding our laws on the sexual abuse of animals. The substitute, which I assume is being distributed, is basically removes some outdated language from the existing code when it comes to.
Is there a substitute or amendment?
There's a substitute we just adopted, Mr. Chairman.
Okay. Yeah.
No. But the bill basically updates some existing language. Well, Mr. Chairman,
Yes.
we took testimony actually from, we took,
And Fairfax County.
yeah. Mr. Chairman, we took testimony from a detective who said that they often find, I guess what could be called animal porn in connection with child porn investigations. Usually the people who are charged know how to delete the stuff that's illegal, but they keep the animal porn because it's not illegal. There's also a high association between people who have an interest in watching this type of video and child porn. It's one of the strongest correlations that exists. And the bill also makes it clear that people who facilitate bestiality, not just the person who does it, but the people who facilitate it or make animals available for it, can also be charged, which right now they cannot. And
Mr. Chair,
Mr. Quagliato has something he wanted to say.
Yeah,
Yes.
Charles?
the difference between the substitute and the original version is
It just clarified on line 25 that the crime also includes possession. In the subcommittee, we heard testimony that it had possessed with intent, and there was concern about, well, is this criminalized just simple possession? And then the second change is on line 30. The introduced version had it, a person could be prohibited from essentially owning an animal for 5 years, and the subcommittee wanted to eliminate that 5-year language. That's the only difference in the substitute in the introduced bill.
Okay.
That's right. So anyway, the subcommittee recommended reporting and referring to finance on a unanimous 5-0 vote. I would so move.
Been moved and seconded that the substitute be reported and re-referred to finance, Senate Bill 249. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, no 0.
14-0. Motion carries. Senator Searle.
Thank you, Mr. Chairman. Senate Bill 310, this has to do with the issue of ghost guns. And this bill is a bit different from the bill we heard last year. The subcommittee took testimony about, from a lot of people actually, but the changes between the original and the substitute is the substitute removed the provision about possession of ghost guns. So the bill that's left basically just makes it illegal to sell or give a ghost gun. And it's a much narrower proposal than the one before. And with that, Mr. Chairman, the subcommittee recommended reporting and referring to finance 6-2 with 1 abstention. And I would so move.
Need to adopt the substitute.
Oh, yeah, I'm sorry. I moved the substitute. I keep forgetting to do that.
All in favor of the substitute, vote aye. Aye. All opposed, no. Motion carries.
So having said that, Mr. Chairman, I would move that we report and re-refer the substitute to finance.
Been moved, and is there a second? Been moved and second to report the substitute and re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, noes 4.
9-4. The motion carries. Next bill.
Thank you, Mr. Chairman. The next bill is Senate Bill 378, which is Senator Peterson's bill. This bill is what's known, I think, as second look legislation. And it basically provides a process where somebody who is serving a sentence for a series of convictions and who's incarcerated can apply for resentencing after a period of 10 years, provided they meet certain conditions. And allows the court to basically modify their sentence. You know, the conditions are things like good behavior. I think they have to be of a certain age, and I believe there's certain offenses that are excluded. But the committee recommended reporting this 4-3, and I would so move that we do that. We report and re-refer to finance.
Okay, it's been moved and seconded that the bill be reported and re-referred to finance. Senate Bill 378. All in favor of the motion, vote aye. All opposed, no.
Ayes 10. Ayes 9, noes 5.
9-5, the motion carries. The bill is reported and re-referred to finance. All right, Senator Sherrill.
Thank you, Mr. Chairman. Senate Bill 379 is Senator DeStuff's bill, and this bill basically would reinstate capital murder for the willful, deliberate, and premeditated killing of a law enforcement officer. We took, again, testimony from the state police and others about this, and it's obviously a difficult subject, but we made our policy statement on that last year, and the subcommittee recommended PBIing the bill on a 5-1 vote, and I would so move.
All in favor of the motion to PBI the bill, vote aye. All opposed, no.
Ayes 9, noes 6.
9-6, the bill is passed by indefinitely. Senator Sherrill.
Thank you, Mr. Chairman. Senate Bill 411 is Senator Morrissey's bill, and this bill basically makes all types of drug possession various misdemeanors. And that's basically what it does. Subcommittee recommended reporting that bill 5-2. Doesn't have to go to finance, right? Okay, so I would move to report the bill.
It's been moved and seconded that the bill, Senate Bill 411 be reported. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
9-6, the bill is reported. All right.
Ready for the next one?
Yeah, next, Senator Serval.
Thank you, Mr. Chairman. Senate Bill 440 is Senator Boysko's bill. This has to do with hazing. First of all, we have a substitute. I'd move the committee substitute.
Is there, all in favor of the substitute, vote, is this a new substitute or the same? Okay, vote aye.
Aye.
Aye, all opposed, no. Motion carries.
Thank you, Mr. Chairman. So basically, the bill is written would make hazing a Class 5 felony, and it also, which we took out, and we basically left it a misdemeanor. It also created a safe harbor for people who report hazing. We left that in. One of the things that we also took out was it had provisions that would allow a hazing victim, or I guess the family of a hazing victim, to obtain a fine against a Board of Visitors member, the university president, and others if they, I guess, knowingly tolerate hazing. We thought that was a little overbroad and took that out. It does leave, I believe, language in that allows, I think, for an injunction against a university who continues to tolerate hazing. But we narrowed the bill down substantially from what it was. And I think the committee knows there's a separate bill that we've already passed off the floor, I think, that has to do with reporting hazing violations and making all that more public. And this is kind of a complement to that. But the committee, I think, felt that taking it all the way to a Class 5 felony for this was a little much, and so we
Mr. Chair.
narrowed it down.
Yeah,
And I,
Senator Dees.
Can I, Senator Serville's question, isn't it true that the language on line 13 ensures that someone prosecuted under this section can also be prosecuted for manslaughter in an appropriate case?
Yeah, thank you, Mr. Chairman. That was actually a big part of the discussion, was making it clear that a prosecution for misdemeanor hazing would not foreclose a prosecution for involuntary manslaughter. There's been some cases that say if there's a more specific offense, then you cannot be prosecuted for a higher offense like involuntary manslaughter. And we wanted to make it clear that you could be prosecuted for both, so that the felony charge would be available to families. And that was another major policy difference we did. I think Mr. Qualiato has something else to say, Mr. Chairman.
Mr. Chair, there is one additional change that was discussed in subcommittee that was adopted in concept, and that was expanding the safe harbor provision. On line 16, the safe harbor is also expanded to include involuntary manslaughter. Steve and I discussed this kind of over the weekend, figuring out what would be the best way to expand it, and we felt it was limited to those accidental acts, and that's why we've included involuntary manslaughter, but did not want to include any intentional acts or acts with malice. So that's the language we decided on expanding the safe harbor.
I think that,
And that safe harbor, Mr. Chairman, that safe harbor is essentially intended to encourage people to do the right thing and report the problem when it occurs. Is that
Yes.
correct?
That's correct, Mr. Chair.
Senator Morsi.
Thank you. Can either the patron,
Yeah. I got a haircut.
either the patron or somebody there, I can't recall, with regard, or staff, with regard to the safe harbors line 18 through 29 and the substitute, if the individual stays at the scene or goes to the hospital or reports it, can that person be prosecuted for some other offense unrelated to the hazing, such as a show cause for a previous matter?
The answer, Mr. Chairman, is yes.
And was further question,
Yeah, Senator
was that
Morsi.
the intent of the patron? That the person could be prosecuted, say, for an offense that happened 5 years earlier, and they don't prosecute him for the hazing because he reported it, but they show cause him for a charge that occurred years before.
Mr. Chair, the intent of the immunity was to address the issue at hand immediately so that they would feel comfortable in saving somebody else's life.
And further, Mr. Chairman, a show cause would require, if it's a violation of the good behavior condition of a suspended sentence, current law would require that that result in a conviction in order for there to be a revocation. And if there's no conviction, then there's no good behavior violation.
Follow up, Steve. So just so I'm clear. on
Senator
this.
Morrissey.
Thank you, Mr. Chair. So I'm clear. The person reports an incident of hazing, stays there, avails himself of the safe harbor position, and cannot, I understand, be prosecuted for anything with regard to the hazing. If that person, though, does the right thing but had a previous conviction and had a suspended sentence, I just need a yes or no. Can that person be show-caused and thus incarcerated for that previous conviction, which was totally unrelated to hazing?
Mr. Chairman, Senator Morrissey, obviously, I mean no disrespect, but few questions in the law can be answered simply yes or no. Yes, a person can be subject to a show cause, but the defense would be that there was no new criminal conviction, hence a good behavior violation would not justify a revocation.
Okay, all right, thank you.
Mr. Chairman.
Any further questions?
Mr. Chairman, having said,
Senator Sherrill.
I'm sorry. Thank you, Mr. Chairman. And having said that, the subcommittee recommended reporting the bill, I think it was 6-1 with one abstention. I would so move. I'm sorry, reporting referring to finance.
Second.
Senator Deeds has a question.
Mr. Chair, with the bill in
Senator
its
Moore.
current form, having adopted the substitute, the bill does not need to go to finance.
Okay,
Okay,
then I would
yeah.
amend my motion accordingly.
Senator Norman.
Thank you, Mr. Chairman. I remain concerned about the broad and rather amorphous approach on lines 45 through 49, where mandamus or injunction can be brought against the president or other presiding official of a school. And I'm concerned if you go up and look under number D, it does provide some autonomy upon the individual schools as to what their student sanction or discipline may be. But if you look at 45 through 49, it does not necessarily incorporate the language on 51, which talks in terms of willfully and knowingly failed. And these can be rather egregious and emotional circumstances, and I just worry that sometimes the administration of our public colleges and universities are not statutes of courage when they have criticisms directed against them, and so I'm concerned about that.
Mr. Chair, if I might respond.
Senator Borsco.
Thank you so much. So this is a fine only for behavior that is willful and knowing. It is no more than a typical fine for a FOIA violation. The reporting was in existing law, although we changed to all incidents, not just bodily injury, but then in this version, it is now only bodily injury. They would have to have clear and knowing evidence that hazing was going on and they didn't do anything about it. And I think that we can all agree that when we have students who are dying at the hands of their classmates over hazing, we all have to take some responsibility for it. And this is one way to help make sure that this is being treated seriously and that the colleges and universities do everything that they can to put an end to it. We know that there have been incidences in the past where students have been gravely injured, and those groups were allowed to come back onto campus. And I hope that we will pass the bill.
Okay, any further discussion?
Mr. Chairman,
Yes, Senator Norman.
not being argumentative, my persuasion and perspective comes not from an emotional or egregious situation. For 3 years, I was the attorney for a college and the president of a college, and I've had some personal experience on how things can evolve, so I understand the intent of the bill, but I'm just not whimsically making my observations.
Okay, any further discussion? I'll say the cases I've had involving hazing, I've had several. The administration knew nothing about what was going on, and I don't think they would have allowed it to happen. In fact, in several cases, they shut down the fraternities. Yeah. Okay, any further discussion? Is there a motion?
I already made it.
Okay, there's motion.
Second.
Have we adopted the substitute? Okay.
Yes.
The motion to report the substitute on Senate Bill 440. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 4.
10-4, the bill passes. Okay, next, Senator Sherville.
Thank you, Mr. Chairman. Senate Bill 475 is Senator McClellan's bill, which has to do with counsel at first appearance. And first of all, I'd move the committee amendment.
Is there a second? Second. All in favor of the committee amendment, say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chairman, basically the bill requires there to be an attorney present at the initial appearance anybody makes after they're arrested, which is typically the arraignment. The amendment basically makes clear that the appearance is a special appearance and not a general appearance by the attorney, so they're not in the case permanently. We heard testimony that this has been done in other jurisdictions and doesn't create. There have been opinions obtained that it's not a conflict of interest. There was some concern expressed by the Supreme Court about their ability to implement this, and there was also concern by at least one of the members of the committee that this would not be possible to implement in some jurisdictions that are sort of more remote and don't have regular dockets. There was also some concern about sort of logistics in the court, within the buildings themselves, to meet with people and stuff. But we also heard testimony that this has been implemented in other places very successfully and avoids a lot of the problems of people being locked up for 2 or 3 weeks in situations where they probably would have been released if an attorney had just been there to explain to them. Sorry?
Okay.
Right, I'm sorry. And then a lot of the logistical difficulties can be addressed with remote video appearances, which are largely used today in a lot of jurisdictions. And so having said that, the committee recommended reporting and referring to finance on a 5-to-1 vote.
Okay, any further discussion? All right, all in favor of the motion to report and re-refer the amendment, the bill as amended to finance, all in favor of the motion, vote aye. All opposed, no.
Ayes 12, noes 3.
12-3, the bill is reported as amended and re-referred to finance. All right, Senate Bill 493, Senator Sherville.
Thank you, Mr. Chairman. Senate Bill 493 is also Senator McClellan's bill. This has to do with people who send, I'm sorry, first of all, let's move the substitute.
Second.
All in favor of the motion to adopt the substitute, say aye.
Aye.
All opposed, no. Motion carries.
Thank you, Mr. Chairman. So the substitute basically completely changes this from a criminal statute to a civil statute, creating a new civil cause of action. And it basically has to do with the situation of people sending lewd pictures of themselves to other people without the recipient's consent. And we heard testimony this is a problem for some, mainly women, but many people who have their cell phone number out in public, where they suddenly will get these things. Senator McClellan altered this to the civil, to create a civil cause of action, which is punishable by, I'm sorry, you could recover actual damages or $500 statutory damages, attorney's fees. Yeah, it's being distributed.
Can I get a copy? I got it.
Yeah, so you can recover statutory or actual damages of $500, punitive damages, and injunctive relief. It has the typical ISP immunity language, et cetera. That's what the bill does. And I'm sorry, Mr. Chairman, I would move the subcommittee recommended reporting referring to finance on a 6-to-1 vote. Although, does it need to go to finance still? No, it's not criminal. Okay, so I'd move to report the bill. And again, it was recommended on a 6-1 vote.
Do we adopt the substitute?
Yeah, we already did.
Okay, all right, any discussion? All in favor, it's been moved and seconded to adopt the substitute.
No, we already did that.
Moved and seconded to report the substitute. All in favor of the motion, vote aye. All opposed, no.
It's just adopted.
Ayes 15, no 0.
15-0, the substitute is reported.
Mr. Chair?
Yes.
Can I ask a few questions?
You go ahead.
And this may be,
Is it about the bill we just?
it's about the bill we have, which is now a civil remedy, but it came out of criminal sub, correct?
Reported it, but yeah.
We just reported it.
Oh, I thought we just adopted the substitute.
We did both.
We don't report a substitute.
I think we adopted both. We
motion
adopted the
was to adopt
substitute
the
and we
substitute.
reported the bill. I'm sorry?
And it's going to finance?
No.
Doesn't have to go to finance. All right, let's move on. Senator Sherrill?
Mr. Chair,
Yeah, Senator Morrissey.
if Senator Peterson wanted to make a point about it, I think we ought to give him the courtesy of letting him do that.
Go ahead, Senator
Yeah.
Peterson, go ahead, quickly.
Well, man, I didn't, I had no idea. I'm sorry. I thought I heard the motion to adopt the substitute, and I apologize if I wasn't listening. But let me ask a question. This may be sort of ex post facto, but what is the tort right now if somebody has a photograph that's embarrassing of another person and puts it in a public place? What would that be? There's a tort right now that addresses that situation, correct? I'm getting some blank looks up here.
Mr. Chair, it could be false light, I suppose. That would probably be the closest thing to it.
The only thing we have, as far as I know, in early 1900s, because I happened to research this years ago, was one of the first right to privacy laws in the country. And it's limited to using a person's name or likeness for commercial purposes without their
Right.
permission.
You can definitely sue them for using your likeness for a commercial purpose,
Right,
but this
that's right.
seems like it's,
Different.
Mr. Chair,
Yeah, Senator Morrissey.
Senator Peterson, this is different than maybe you're thinking of legislation that we passed dealing with what was known as revenge porn. This is not that. This is a situation where a picture of somebody in a state of undress is sent to another person or group of persons, and somebody takes umbrage at it. I'll give you the scenario. So you have 3 adult males that send it to or an adult male sends it to his fraternity brothers, and one of them doesn't like it. It's not targeted at an individual, but doesn't like the unseemly nature of the photo that was sent. He could file this civil action.
okay, let me ask one follow, and I
Yeah,
apologize.
Senator Peterson.
I literally got the substitute in my hands after we had already voted, so. It says, such other person has not consented to the use of his computer or electronic communication device, i.e. iPhone, for the transmission of such material, or has expressly forbidden the transmission of such material. So what you're getting at is somebody's photo of themselves or somebody's photo of their girlfriend or boyfriend? Is that
Mr.
what
Chair.
we're talking about?
Yeah.
Mr. Chair.
Senator
Okay.
McClellan.
It could be a photo of themselves, it could be a photo of someone else, but it has to meet the definition of an intimate image, which is on lines 13 to 15. Basically, this is getting at, if someone walked into this room right now and exposed themselves, they could be charged with indecent exposure. But if someone sent unsolicited to an individual, or against their after they've been expressly told that by that person they don't want it, a picture of the exact same thing, nothing can happen. And so what this bill is doing is providing the person who received the photo the civil cause of action for either actual damages or $500, whichever is greater, or injunctive relief to prohibit that person from sending additional photos.
Okay, one follow-up question.
Senator Peterson.
It uses the word conversion. I understand conversion to be taking something from somebody else and converting it to your own use.
What line?
That's on line 20. it says shall be considered a conversion. So that to me is something different. If I take a photograph from your iPhone and text it out to the world, that may be a conversion because I'm taking your property and sending it to somebody else. But what Senator McClellan is describing is something different. It's if I give somebody something they didn't ask for, that's not a conversion.
Mr. Chair,
Senator Charles.
in coming up with this language, the way Steve and I looked at this was as more of a trespass. And I'll say Steve took the position of receiving something on your phone that would be otherwise unwanted would be a conversion in the sense of it's taking your property and rendering it not to your use.
Okay, trespass and conversion are two very different concepts.
Correct, Mr. Chair.
So which one is it?
Steve felt conversion was more applicable. I would tend to think trespass may be more applicable. We could, if the committee feels it, shall say such material shall be considered a trespass and shall be liable if the committee is more comfortable with trespass than conversion.
I don't want to slow the train down here, and it may seem meaningless to most people, but this is not a conversion. It's exactly. If I text somebody a photo that they don't want to see, that has nothing to do with conversion. Conversion is when you steal something.
Mr. Chairman,
Yeah,
Senator Peterson.
Charles, Steve Benjamin.
This is what I do. I don't.
Understood, and here is where I was coming from. If somebody takes your property, that is your phone, and uses your phone, if somebody sends data to your phone that causes that takes over your phone and causes it to display something that you do not want on your phone.
Great. Steve, I
right,
do civil
Senator
practice.
Peterson.
I understand. AOL? I think.
Well, I know, but
the
we're
same
talking about
theory.
two different situations.
Then I
One
think-
situation, let me speak, sir. One situation is someone is taking an image from somebody's phone and sending it to another person without permission. That's a conversion. Another instance is where someone is knowingly using a photo on their own phone and sending it to somebody who doesn't want to see it. That may be a trespass, but these are two separate ideas here.
Well, it could be
I need to know which one
we're
the senator
defining
is
as
trying to get
conversion.
at.
Senator Morrissey.
I think Mr. Benjamin is correct, but I got two questions, and just to answer if either scenario would be captured under this law. If a woman sent me a picture of herself in a state of undress, and I looked at it and said, this is offensive to me, I didn't solicit it, and I said I didn't want it, would I be able to avail myself under this code section?
Yeah.
Yes or no?
Mr. Chair, it does say not consented, not solicited, so
I didn't solicit it, it was sent to me, unsolicited. Would I be able to avail myself under this code section?
I would say, Mr. Chair, it depends. Soliciting and consenting are two different things. If from the nature of the conversation, it appears that there was some sort of consent given, even though it was not openly solicited, the statute would not apply. I think trespass is a friendly amendment.
I think, to be blunt, and I think the bill we just passed has to do with taking somebody's iPhone, sending an image from their iPhone without their permission, and that is considered a conversion, but that doesn't seem to be what the intent is.
Mr. Chair,
Yeah, Senator McClellan.
having voted on the prevailing side by which we report at Senate Bill 493, I move that we reconsider that vote for the purpose of an amendment.
Is there a second to the motion to reconsider? Second. All in favor of the motion to reconsider, vote aye.
Ayes 15, no zero.
Mr. Chair,
The bill is reconsidered. Yes, Senator McClellan.
I move that we, on line 20, strike conversion and insert trespass after A.
Mr. Chairman?
Yeah, Senator, Steve.
Perhaps a better amendment would be to, on line 20, insert the words "or trespass."
No.
Mr. Chairman. Mr. Chairman.
Mr. Chair.
No, wait a minute. Stop, one at a time. Who?
I've been on the.
Yes, Senator Peake.
Mr. Chair, see, when I read this, the conversion part to me, Senator Peterson, is if your girlfriend sent you a picture of herself naked.
Right.
And intended only you to see that picture, and you converted that picture and sent it out to the public. That's what the conversion is in this, which is the revenge porn.
okay, but-
That's the way I read this.
Mr. Chairman?
Yeah.
Mr. Chair.
Senator Peterson, you want to respond to that?
Yeah, the problem is this is not that bill. This bill has to do with the recipient.
Right.
So that's why conversion is the wrong
Mr.
word.
Chair.
Okay, all right. Senator Norman?
Mr. Chairman, we have an incredible mountain of work to do. Let's send this bill back to subcommittee, get with Senator Peterson and work it out.
We just adopted an amendment to fix the problem.
Oh, okay, we got to,
But there's still, Mr. Chairman, I think there's still a debate about the language. I'm not being argumentative. We're just eating up a lot of time.
okay, Senator Deeds?
I was just going to suggest that this bill go back to the Civil Law Subcommittee to get
I
right.
think this is literally a 2-minute fix, and I'm happy to do it. I just think there was,
Okay, is there a motion, one way or the other?
also move.
Carry over for the day.
I'm not going to vote for it like this, Jennifer. We can get this.
Motion to, Senator McClellan?
I know, but
That way you can have it Wednesday.
Senator, all right, Senator, all in favor of the motion to carry this bill over for the day, which means Wednesday? All in favor of the motion, vote aye. Aye. All opposed, no. Motion carries. The bill will be taken up on Wednesday. Okay, next.
Thank you, Mr. Chairman. Senate Bill
Senator
518, we could skip that because that one got rolled into a bill coming up later.
Okay.
The Senate Bill 643. Senate Bill 643 was Senator Ebbins' bill, which has to do with altering serial numbers on firearms, which was very interesting because Senator Ebbin had the support of VACDL, which is something I'm not sure we'll ever see again. Is he even here? But the bill basically makes it a Class 6 felony for any person to, for a firearm dealer to have a firearm that has an altered serial number, and it makes it a Class 6 felony for any person, firm, association, corporation, et cetera, to distribute any firearm with an altered serial number. And
Yes, there's a substitute. Go ahead, Senator Sherwood.
I'm sorry, yeah, there is a substitute.
Okay. The substitute's been moved. Is there a second? Second. All in favor of the motion to adopt the substitute, say aye.
Aye.
Aye. All opposed, no. Motion carries.
Thank you, Mr. Chairman. And the substitute made it clear that the transfer has to be made knowingly. So there has to be intent. That's the difference between the substitute and the original bill.
Okay.
And the subcommittee recommended reporting and referring to finance on an 8-0 vote, and I would so move.
Is all in favor of the motion to
Mr. Chairman.
report? Yes, Senator Obenchain.
I don't think I've got the substitute, but if
Can we distribute the substitute?
if I own a gun that I got from my grandfather, and it has no serial number on it, somebody eradicated it, I've got no idea who, or maybe it just never had one on it, and I give it to my son, am I running afoul of this bill?
Mr. Chair,
Yes, Charles.
to answer Senator Rubenstein's question, if the bill was required to have a serial number, and the serial number was then defaced or removed or altered, then you would be in violation. If the firearm was not required to have a serial number, then you would not be in violation.
So, further question.
Yes, Senator Obenchain.
So, if I acquired a gun from, a legitimate source, from my grandfather, and it was required to have a serial number, it does not. I have lawful possession of it, and I transfer it to my son. I've run afoul of this legislation. Something I lawfully own, I can't possess or transfer. Is that right?
Charles?
Mr. Chair, I would answer there's the two separate provisions of the bill that you would both run afoul. One would be to possess a firearm whose serial number has been removed. And then the second would be if you transfer such firearm. Under current law, the only prohibition deals with the actual removal of the serial. This bill was seeking to clarify that possession of a firearm with a removed serial number, as well as the subsequent transfer of a firearm with a or remove serial number would be illegal.
Further-
The substitute is available online, and the only difference is it inserted knowingly
And
in
for-
that subsection C.
Further question.
Yeah, Senator Obenshain.
Am I correct in assuming that there's no compensation provision that would compensate me for destroying or getting rid of that firearm?
That is correct.
And what do I do with it?
Charles?
What you would probably have to do with it, I know there are gun buyback programs. That is probably what you would have to do with it, would be to, if you have possessing a weapon that is now contraband, return it to the Commonwealth to have it destroyed.
You could buy a serialized part.
Okay, any further questions? Okay. Is there a motion?
Mr. Chairman, I already moved the report and re-refer the bill to finance.
Okay, the
It was
bill-
the vote in committee was unanimous.
Okay, the motion is to report the substitute and re-refer to finance, Senate Bill 643. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 5.
10 to 5, the bill is reported and re-referred to finance. Next.
Thank you, Mr. Chairman. Senate Bill 687, Senator Mason's bill, which was identical to Senator Obenshain's Bill 126, and notwithstanding the lower bill number by Senator Obenshain, he agreed that he would like to be incorporated into Senator Mason's bill. So I'd first of all move to incorporate Senate Bill 126 into Senate Bill 687.
Senator Obenshain, the chief co-pilot.
And make Senator
Okay, it's
Obenshain
been
chief co-patron.
Moved and second to refer Senator Obenshain's Senate Bill 126 into Senate Bill 687 and make Senator Mason and Senator Obenshain chief patrons. All in favor of the motion, vote aye.
Aye.
I think you got to
It's not
vote on the
recorded.
board.
Oh, yeah, it is recorded.
Vote on the board.
Ayes 15, no 0.
Okay. Now
Thank
we
you.
have Senator Mason's Senate Bill 687.
Thank you, Mr. Chairman. We had a substitute which took two words out, I think, and I would move the substitute.
Been moved and seconded to adopt the substitute. So Senate Bill 687, all in favor say aye. Aye. All opposed, no. The motion carries. All right,
Thank-
Senator Mason, Senator Serval.
Thank you, Mr. Chairman. So this bill was a recommendation, I think, of the VCJC, and it has to do with, I guess, modernizing, updating some terms, incapacitated adult to vulnerable adult, which would apply to over the age of 18, basically people who are subject to disabilities, mental impairments for various reasons, and basically taking advantage of them. And it basically, I think it basically creates, makes it clear that taking advantage of a vulnerable adult under various circumstances can result in criminal liability. And again, just clarifies that definition. So it means anybody who, by reason of mental illness, intellectual, developmental disability, physical illness or disability, or other causes, including the extent the adult lacks sufficient understanding or capacity to make or communicate or carry out reasonable decisions of his well-being, and take care of themselves. And so it makes the definition clear. Right now, under current law, the type of person that is subject to the type of victim that this would apply to is not clear. And that's basically, I think, what the bill does. And again, it was a recommendation of the VCJC. I think we recommended reporting it on a unanimous vote.
Yeah.
7-0. I would move to report and refer the bill to finance on that.
Been moved and seconded to, is there a second? Yeah. Moved and seconded that Senate Bill 687 as a substitute, which is a recommendation of Virginia Criminal Justice Conference, be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, nays 0, 1 abstention.
14-0, the bill has been reported and re-referred to finance. All right, Senator Searle.
Thank you, Mr. Chairman. A couple more. So Senate Bill 729. First of all, that was similar to Senator Spruill's Senate Bill 41. And again, notwithstanding his lower bill number, Senator Spruill asked if his could be incorporated into Senator Ruff's. So I would move to incorporate Senate Bill 41 into Senate Bill 729.
And make both chief.
May make them both chief co-patrons.
Okay.
Thank you, Mr.
All
Alternate
right,
Chairman.
all in favor of the motion to report, to refer, to roll Senate Bill 41 into Senate Bill 729, and make both Senator Sproul and Senator Ruff co-patrons. Vote aye, all opposed, vote no.
That's 15-0.
15-0.
Thank you, Mr. Chairman. Next, I believe there's a substitute.
There's a substitute to the bill.
Second.
Yeah, move the substitute.
It's been moved and seconded to adopt the substitute to Senate Bill 729. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries.
Thank you, Mr. Chairman. Having said that, so this bill deals with the increased prevalence of catalytic converter theft. I guess there's a scarcity of platinum, and a lot more of these have been getting stolen than usual. And even though stealing, I mean, a typical used catalytic converter coming off a car is worth less than $1,000. So a lot of people.
Cases less than 150.
Right. So, but the cost associated with repairing the car is significant. So some people feel like we need to have increased penalties for this. And basically, what the bill does is it takes part of Senator Sproul's bill and part of Senator Ruff's bill and puts them together. Senator Ruff wanted to make it a felony. We left it at misdemeanor. Senator Sproul, and I'm sorry, Ruff also had some civil stuff I'll get to in a second. Senator Sproul wanted to make it a crime to conspire to steal a catalytic converter so that somebody who was the lookout could be charged. And basically, the committee didn't like the idea of creating a new conspiracy to commit a misdemeanor because we only do that for 1 or 2 misdemeanors right now. So instead of doing that, we made it a crime to aid and abet a violation of stealing a catalytic converter. So that's the language that you see on lines 22 through 24. And then the language on lines 70 through 81 is from Senator Ruff's bill. And that basically increases the requirements and record-keeping requirements for these used car part guys who get these catalytic converters. And it basically is the same thing that we do with pawn shops and other types of businesses to make sure they're not trafficking in stolen parts. That's what the bill does. The committee, with all that, recommended reporting it 7-0, and I would move that we report and re-refer. Do we have to go to finance still?
Not in the current substitute.
Got it. So I'd move that we report the bill, period.
And to go to finance?
No.
Okay. All right, the motion's been made to report Senate Bill 729. Is there a second?
Second.
Second.
Any discussion on the motion? All in favor of the motion to report Senate Bill 729, vote aye.
Cutting a catalytic converter off a car ain't something you can do in a minute or two.
That's 15-0.
Okay. Motion carries. Next is Senator Sherrill.
Thank you, Mr. Chairman. This is the last bill, which is Senate Bill 745, which is my bill. And first of all, I would move to incorporate Senator Lucas's Senate Bill 518, which she has consented to do and notwithstanding her lower bill number. So I'd move that first.
Okay, is there a motion to, so what's the,
It's
report?
incorporate 518 into 745.
Okay, report 518 into 745?
Right.
Okay. All in favor, second, all in favor of the motion, vote aye, all opposed, no.
That's 15-0.
Okay.
Thank you,
Motion
Mr. Chairman.
carries.
Secondly, I'd move to adopt the substitute.
Okay, is there a motion to adopt the substitute? And there a second? All in favor of the motion to adopt the substitute, say aye.
Aye.
All opposed, say no. Motion carries. Substitute's adopted. Okay, Senator Sherrill.
Thank you, Mr. Chairman. This bill that you just adopted the substitute of has to do with people who are currently incarcerated for marijuana-related convictions or offenses where their sentence was increased because of a prior marijuana-related conviction. Senator Lucas's bill basically said all these people should have the opportunity to get resentenced within a period of time. My bill basically sent it all to the parole board, similar to what we did with Fishback. And the substitute before you takes a hybrid approach to that. So basically, anyone who is convicted of a marijuana-related primary offense basically gets to, they can apply to be resentenced through a 2-year period. And anyone who is convicted of something, of a different offense, a non-marijuana offense, but it had a marijuana offense with it, or if their sentence was increased because of a prior marijuana-related conviction, those people can apply through the parole board to a modification of their sentence. I think that's basically what it does. This was sort of a loose end from the marijuana bill last year that we had actually hoped to take care of, but kind of ran out of time. Okay. And the committee recommended reporting and referring this bill to finance 5-0.
Okay, is there, Senator Morrissey, do you have a question?
Senator Servo, was there some discussion in this bill, or was there another bill where the application, Senator Lucas, was made to the sentencing judge? Is there a bill out there where this was it? Well, there was a bill where the application was made to the judge for resentence.
Mr. Chairman,
Senator Sherrill.
that's this bill. And as I said, if under, I believe it's subsection A, if you have a marijuana felony conviction and you're currently imprisoned, you can apply for a resentencing.
To whom?
Yes, Senator Morrissey.
To whom, Senator?
To the court where you were sentenced. And most courts I'm familiar with put you with the original judge. Unless that judge is retired, then they bring in somebody else who has taken over their sentencing docket, at least in the jurisdictions I practice in.
Okay, so
Any
final
other
question.
Senator Morrissey.
What, can you just distinguish between applying to the judge, which I think is a good idea, versus your comment a moment ago about applying to the parole board? That's where I'm confused.
Okay, as I said, this sets up two systems. One is if you have a marijuana-related conviction, and that's all you have,
Right.
then you go back to the judge. If you have a different charge, say you were convicted of malicious wounding and marijuana distribution, then you have to go to the parole board. Or if you were convicted of malicious wounding, but because of a prior marijuana-related conviction, your sentencing guidelines recommended a higher sentence, you can apply that one to the parole board.
Okay, thank you.
Good. Any further questions? Everybody understand the bill? Okay, is there a motion?
Mr. Chairman?
Yeah,
I already made it.
Motion to report the substitute and re-refer to finance Senate Bill 745 that incorporates Senate Bill 518. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
9-6, the bill is the substitute is reported and re-referred to finance.
Thank you, Mr. Chairman. I think that's it.
That completes the criminal law subcommittee. Okay, now we'll move on to the full committee, and I'm turning over to my distinguished co-chair, Senator Deeds.
Senator Serval, you have the first bill,
Oh, I do?
348. Senate Bill 348, and I think that's the bill that essentially reenacts legislation that passed last year. Is that correct?
Mr. Chairman, while Senator Serval is getting set up, we have a technical amendment for this bill. On
Okay.
page 5, line 269, strike 42 CFR Part 433 and insert 45 CFR Part 300. Thank you.
What line is that?
Page 5, line 269.
Okay. Okay, do I have a motion on that amendment? Okay, all in favor of adopting that amendment, say aye.
Aye.
Okay, Senator Serval, your bill.
Thank you, Mr. Chairman. No, this bill is actually a bit different from last year.
Okay,
So, first of all, the bill does three things.
okay.
On lines 26 through 30 and 161 through 65, it reverses the case of Myers v. Myers. The Court of Appeals held that if you file for child support in juvenile court, and while the child support case is pending, somebody files for divorce, what happens is the child support case goes away and everything's transferred to circuit. And the Court of Appeals held that if you do that, child support is only retroactive to when the divorce was filed instead of when the child support case was filed. And so say a child support case could have been pending for like 7 months, and you could sort of lose 7 months of child support. And so this basically says if that happens, support's retroactive to when the child support case is originally filed, not the divorce case. So that's the first change. The second change is on lines 42 through 43. That reverses a case called Wills v. Wills, which the Court of Appeals decided last year. And what this one does is it makes clear that prejudgment interest can be awarded on a child support arrearage all the way back to the date you file the child support case. The Court of Appeals held that you can only get prejudgment interest on a child support modification, but not an initial petition.
What year was the Wills case?
2021.
Okay.
And basically, it has the effect of giving the child support payor an interest-free loan to the person who's supposed to be receiving the child support, which is kind of wacky. And there's no reason that you should only get prejudgment interest on a modification instead of an initial proceeding. So those two changes are the easy ones, I think. And I'm not aware of anybody that opposes those. The Family Law Coalition supports both. The more complicated part is the part you were referring to earlier, Mr. Chairman, which was the bill we heard last year and passed. This time it's a little different. And this one's kind of messy. So this has to do with...
Well, this is the part as I understand it, if we don't pass, we'll potentially lose $76 million in federal money.
Yeah, it might be more than that. Yeah, there's like about $75 million of federal money at stake. And so the feds fund a big part of our child support enforcement program. And the Obama administration adopted regulations, I don't remember when, like in 14 or 16 or something, or that we had a window to meet, our window's about to shut, which basically say that we are required to modify our child support statutes to say that incarceration, imprisonment, is not voluntary unemployment or underemployment. And if we don't do that, we're going to lose all this federal money that funds our child support enforcement program. The problem is, the law in Virginia on this goes back to the 1950s, I think. And so what we've done in the bill is basically done what is required by the regs, but the nuance relates to which cases does this apply to. So the way we've dealt with this before, whenever we change the factors for child support, things that you can get a deviation for, what we say is you're not allowed to file a child support modification petition because we changed the law, right? Because the people who already have a child support judgment, they already have a fully litigated, valid final judgment. We can't take away judgments from people. We don't have that power. We can't take away a personal injury judgment, a breach of contract judgment. We can't take away anything because once you have it, you have a vested property interest. So what the enactment clauses basically say is that the only people that can file to modify child support and utilize this new law are either people that file brand new petitions, they're brand new child support cases, or people who file for a child support modification, but they have a different basis for modification in addition to the incarceration. So, for example, health care changed, child care changed, income changed, a kid emancipated, something like that. If something like that happens, then you can reopen the case and file, but you can't file for modification solely because we changed the law. That's basically what the enactment clause says. DCSC, by the way, we ran this, I sit on the child support work group. We argued about this in the child support work group for probably an hour and a half. Child support work group couldn't agree on a position, including the position the DCSC want us to take because of these issues that I'm talking about right now. And so the solution I came up with is what I just talked about was the enactment clause, but I also have under enactment clause number 3, a sort of a provision that says that if the feds come back to us and say that we're not meeting federal law because of the second enactment clause, then the second enactment clause goes away. So that, I mean, we've done this before with other types of I think Senator Eben had a bill a few years ago about driver's license suspensions where we had to get DOT approval before the license, getting rid of the license suspension for marijuana possession. It's like that.
But that's the 180-day qualifier you've got.
What's that?
180-day qualifier. They have to come back within 180 days.
Yes. But also, just the last thing I'd say, Mr. Chairman, is that we have sent this language to the feds, and whatever it is, I forget, HHS or somebody, Office of Child Support Enforcement at the federal level, they came back and said originally that they didn't think that this language in this bill that you're looking at right now met the terms of the regulations. The way they described it to me, I wrote back to them and said, you didn't read the bill right, that's not what it said. And on Thursday, last week, they wrote back and said, can we have a phone call about this? And so we haven't been able to schedule, I tried to meet them over the weekend, they didn't want to meet over the weekend, I guess, because they didn't agree. So we're probably going to have a conference this week to talk about this language and whether it meets the term of the statute.
Okay.
The federal regs, I mean.
Okay, so the bill does three things. It overturns two cases you apparently lost in the Court of Appeals.
No, they weren't my cases. They weren't my cases.
And then it tries to bring us into compliance with federal law. Does everybody understand? Do you have questions of Senator Servell? Yeah, I think so. Okay, 2 minutes from each side, people that are for the bill, please come up.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Good morning, Mr. Chair, members of the committee. Valerie LaRue from the Virginia Poverty Law Center. We do support this bill, all the parts of it, all of the different things that it does. I'm not sure whether that last part will satisfy the federal government, but I have some ideas about how, if they come back and say that it doesn't, about how it might be able to be fixed. So yes, we're definitely in support of this. You'll probably hear from the family law that they're not in support of that aspect of it. The difference between us and them in terms of why we support it and they don't is that low-income people really rely on the Department of Child Support Enforcement, whereas people who can afford some higher-priced lawyers generally don't rely on the Department of Child Support Enforcement. Thank you.
Thank you. Thank you very much. Anybody else in favor?
Mr. Chairman, there are two people online.
Okay.
Daniel.
Do we have another person in the room that's in favor?
No, she's not.
Okay. People online, yes, ma'am.
Daniel Gray, please unmute and begin your testimony.
Thank you, Mr. Chairman, members of the committee. Dan Gray speaking on behalf of the Virginia Family Law Coalition. We do support the provisions of the bill with regard to retroactivity, with regard to interest on arrears. We oppose the underlying federal policy that allows incarcerated individuals to seek modification based on the incarceration. However, Senator Servell's approach at the end of the bill, the enactment clause, is about the best way we've seen to handle the matter, and so we support that. Thank you.
Lawrence Dale, please unmute and begin your testimony.
Mr. Chairman and members of the committee, thank you. The Myers case was actually our firm's case, but anecdotally, there's a conflict of some anecdotally between circuit court judges. Some have done it retroactive to the juvenile court filing in that first issue, and some have not. This clarifies that and is a good policy. As to the amendments that Senator Servell has put in there, the key case on this is one called Gaynor versus Hurd. It basically says if you change the substance of a law, that can apply to an existing case. It changes the terms of what you are going along with. It's almost like a res judicata, as he pointed out. And this is as substantive as you can have. So I'm still concerned as an academic. I've written a treatise on family law. I've written many statutes, as many of you may know, that you've enacted over the years. And I've commented in my treatise on retroactive application of new laws. In my opinion, this would, even apart from all of what is valid or invalid, that would have to be up to this Court of Appeals. But in my opinion, Gaynor versus Hurd and many other cases would support the problem we have that it should not apply except to new cases filed after July 1, which is exactly what the senator has in there. And if that's voided later by the OCSE federals, then there still could be an argument on case law that it would be a problem. Okay. But we need to get this bill passed. I support the way Senator Servell has done that. Thank you.
Mr. Chair, question.
Senator Morrissey's got a question.
To the gentleman that just spoke.
Mr. Deal, are you still around?
Yes, I'm here. Yes, sir.
Is it Mr. Beal?
Deal.
Deal, with a D.
Excuse me, Mr. Deal, you were on the side of the litigation that did not prevail in the Court of Appeals, is that correct?
In the Myers case, yes, sir.
My question is that we're on a fast train down a narrow track here. I'm just curious, the way Senator Surville presented the bill, the Court of Appeals got it magnificently wrong. You said that they've got it wrong. What am I missing? It was such a clear case, such a clear error by the Court of Appeals. How did that happen? I'm just getting the feeling that I'm not hearing the other side.
All right. Actually, procedurally, it was a little distinction. The juvenile court proceeding was not actually divested by the circuit court's divorce. It was an appeal that they merged. So there's a distinction in procedures. I know, Mr. Morrissey, you've practiced family law, Senator Morrissey, for many years. So technically, but it still should have applied one way or the other. If it was merged, it's still the same principles. And all we're trying to do is to protect the interests of children as a policy matter. And the bigger problem, I think, is not so much the Myers case itself, but the diversity of opinions between circuit court judges around the Commonwealth and anecdotally we've heard about. So we want to clarify it, and this is just good policy.
Okay, thank you, Mr. Deal. We've got 2 minutes for people that are opposed.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
Come on up, you're first.
Mr. Chairman and Senators of the Judiciary Committee, Barbara Lucina for the Department of Social Services in my role as the Director of the Division of Child Support Enforcement. To be clear, the department does not oppose this bill. The department has recommended amendments, and the administration has also provided the department with a position of amend. You do understand clearly that this is the last opportunity for there to be legislation passed that brings Virginia into compliance with the federal requirements of this regulation. You have not been informed yet this morning that this regulation would impact less than 1% of the cases on the child support caseload. 99% of the cases would essentially have no impact. 100% of the cases would be impacted if the appropriate language that is compliant with the federal regulation is not passed. And those families benefit from the collection of an average of $650 million on an annual basis by the division. They also benefit from a range of services, including the establishment of paternity, securing health care coverage, issuing income withholding orders, recording and dispersing the entirety of all of those payments. There is no other agency that can provide those services. And so without the division, those families would be required to seek the assistance of an attorney or be left to fend for themselves. And the department has offered to Senator Surville the amendments that will bring us into compliance.
You've talked with Senator Surville about the amendment?
We have.
Okay. Okay. Were there people online that wanted to speak on this bill?
Mr. Chair.
Mr. Chair.
I'm sorry, I was just asking a question.
There's no one online, Mr.
There's nobody
Chairman.
online? Yes, okay, who was asked? Could
I have a question to the
Senator
young?
Peterson.
And ma'am, you represent which agency or organization?
Division of Child Support Enforcement.
Division of Child Support Enforcement. Okay, help me here on this Senate Bill 348. Is your disagreement with the underlying policy, or is it with the second enactment that makes it prospective? Is it third enactment? Second and third. Second and third enactment that makes it prospective from July 1, 2022. Is that your issue, is with the enactment clause?
Mr. Chairman, Senator Peterson, the division provided to the Office of Child Support Enforcement the introduced bill. They returned to us their compliance review.
Okay, can you start with a yes or no and then explain? My
Yes.
question is your disagreement with the second enactment or is it with the underlying bill? And if you could just start with that and then explain, please.
The division takes no position on the bill prior to line 146 on page 3.
Okay.
Starting with the provisions after line 146 on page 3, following a compliance review from the Federal Office of Child Support Enforcement, the amendments that were offered are on page 4 in line 82, striking alone and also striking other than failure to pay child support or for a crime against the child. Page 4, line 86, the same, other than for failure to pay child support or crime against the child.
186.
Correct. Page 5, lines 256 and 257, striking alone and other than for failure to pay child support or crime against the child, and striking lines 263 through 273, essentially both enactment clauses, which would be completely unnecessary if amended otherwise.
This bill has to go to finance if it passes.
So just to summarize, do you think that people that are incarcerated, that should be considered voluntary unemployment, or it should not be?
The requirement from the Federal Office of Child Support is that incarceration should not be treated as voluntary unemployment.
So that's your position?
The department's position is that operating a child support enforcement program for the citizens of Virginia is good policy.
Okay,
And she has to be in compliance with federal law.
Mr. Chairman.
Senator Peake.
Has Senator Sorrell agreed to the amendments that you need to make, or the Division of Child Support says needs to be made? No. Okay, so the bill as it sits now, it's your position as head of the department that it will take us out of compliance with the feds. Is that correct?
They've told us the same.
They've told you that. Sort of. But they sort of told you that. All right.
Okay, let me. Senator Peake, as I said, the feds wrote an email that said they've read this language and they said it takes us out of compliance. And they described the bill. And I wrote back to them and said, you're not reading it right. Here's what it does. And they wrote back on Thursday after the House killed a similar bill and said, can we have a conversation about this? And I tried to set it up on Friday, Saturday, or Sunday, and there wasn't time. And so I think that conversation will probably happen before the bill goes through finance to give us an opportunity to make amendments.
Here's the bottom line. This bill has to go to finance today if we're going to deal with it. And I would suggest that we deal with it that way. We report it and re-refer it to finance. And
Senator Morrissey.
Senator Morrissey, I apologize.
Senator Servo.
Yeah.
According to the young lady that just testified, if we accept Department of Child Support Enforcement's amendments, we would be in compliance with federal law. Good. That's something that we all agree upon. You're not willing to accept those amendments because you think that that is an inaccurate statement. Okay. Why will you not accept those amendments?
There's a broader policy at stake here, okay? And just so you all understand how child custody and child support works is once you get an order, that order can be modified only upon a material change in circumstances. The reason is that's how we apply res judicata in child support and child custody. Something important material has to change, okay? So just keep that in mind, number one. Number two, I also strongly believe the government cannot take away a judgment that you've obtained by statute. We can't pass a law that says every personal injury case in the last 12 months doesn't apply anymore. And I'm telling you, what's coming for us sometime in the next 10 to 20 years, somebody's going to file something to change the child custody factors. Say we're going to mandate a presumptive 50-50 custody in every case, or say that some other factor has to be considered. If we establish the policy that we can change judgments by law or create an opportunity to change judgments by law in these family law cases. The second we change the custody factors or create a 50-50 presumption or whatever, you're going to get 1,000 custody petitions filed. And I'm just making clear that you have to show something else besides the change in law, something else besides the change in law in order to avail yourself of the new law. That's how we've handled the other 3 changes we've made to this statute since 2009. And it's reflected, I think, in subsection F of 20-108.1. It specifically says that a change in law doesn't apply.
Mr. Chairman,
Senator Morris.
my question is to you. Should we be vetting whether or not we should accept these amendments and thereby be in compliance with federal law in this body, or are we better prepared and able to vet whether or not to accept those amendments in finance?
In a perfect world, we ought to do it in this committee. We don't live in a perfect world. We've got a bunch of bills ahead of us, and that's why I'm suggesting that we send it to finance and move to the next bill.
Thank you.
So I'll take a motion to report and re-refer to finance.
Second.
Okay. All in favor of that motion, say aye. Vote aye.
Vote, you got to vote.
That's right. Okay, you've got the next bill, Senator Servell.
Ayes 11, noes 3.
742.
1 abstention.
742, it's also a bill that has to go to finance if we agree to report it.
Thank you. And I've got some amendments to it that were requested by the Supreme Court. I'd move the amendments, line amendments. They're coming to you.
Okay. This bill, as I understand it, has some provisions that somewhat conflict with Senator Evans' bill that's going through another committee.
It has to, maybe it conflicts with the big marijuana bill,
Yeah, that's what we're talking
but
about.
we're going to conform the big marijuana bill to whatever we do on this, I think
Okay.
is the idea.
Okay, what are your amendments?
The bill, and can we adopt the amendments?
The amendments.
The Supreme Court requested these to make it clear that legal aid or legal aid justice center can avail themselves of the court-appointed attorney fund for expungements. And then I think the Supreme Court asked for some amendments to clarify exactly which cases this was applicable to. Is that right?
Essentially, yes, Mr. Chair. They wanted some clarifying language that sealing of the suspended sentence and probation violations had to be done by petition-based because there was no easy way to find it automatically.
Maybe I could explain the bill and it might be clear, but.
Well, do we have a motion on the amendments?
So moved.
Second.
Second.
Okay, all in favor of the amendment, say aye.
Aye.
Opposed? Okay, the amendments are adopted. Explain the bill, please.
So the first thing that it does is cleans up some terms. You all might remember, we've had expungement for years, but we created this new concept called sealing last year. And they're different. They're different in effect in terms of what the ultimate outcome is. They mean different things. Expungement basically is only applied to things that are actually innocent of, and basically all the files are taken and put in a lockbox, and sealing is a little bit different. Basically, the records stay at the courthouse, but they're sealed in a way you can't see them, and they disappear from your criminal history. When the governor's amendments to the marijuana bill came through last year, the governor added the ability for marijuana convictions to be automatically hidden, but they called it expungement, even though it was really sealing. And so now, because expungement is really expensive, sealing is a lot cheaper. But in any event, the problem is now we have basically 3 concepts in the code: expungement, sealing, and automatic expungement, which is really sealing. And so this makes it clear that automatic expungement is really automatic sealing. So it just cleans up those words to make it clear, so there's not a bunch of confusion out there, so people understand what it is they're getting. They're not getting an expungement, they're only getting sealing. I think that's important for a lot of reasons. That's the first change it does. The second thing is that the bill we passed last year says that anytime you file a petition to seal a charge, the petition itself is sealed, so that somebody can't see your filing to seal your charge. Right now, on expungement petitions, different clerks handle it differently. Some clerks treat them as sealed, some clerks leave them open. And I can take you on, for example, a circuit court website where you type in a common name and you'll see a whole bunch of expungement petitions, which kind of defeats the purpose of getting something expunged. If you can just go look and see they petition to get a charge expunged. So this just makes the two the same. They're both sealed. The third change is that this was, I think, something that was unintended. We also created a new civil cause of action to be able to sue these background check companies and data brokers for continuing to publish information about charges that have been sealed. And in exchange for that liability, we also gave them the ability to register with the state and get a list every month of all the offenses that have been sealed so they can clean up their database. They can't get that right now. However, we thought we also were applying that scheme, the registration scheme and the list and all that stuff to expungement, but we didn't. It only applies to sealing. So right now, you'll be able to sue under state law a data company for publishing a sealed charge, but not if they publish an expunged charge, which you're actually not innocent of. And so we're making those the same. And the data broker background check companies should actually be okay with that because it gives them a list of the expunged charges, which they've been begging us for like 8 years. And I've given the bill to them like 3 weeks ago, and they haven't gotten back to me, but they should like that. The last thing it does is the bill we passed last year creates a new fund for court-appointed lawyers to handle sealing petitions. But again, it didn't apply to expungements, which I think was an oversight. And so this makes it clear that that fund can apply to both.
So this bill just essentially cleans up last year's bill?
Yes.
Okay. Any questions for Senator Serville? 2 minutes for people in favor of the bill.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised on the Zoom at this
2
moment.
minutes for people opposed.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised
Okay,
at this
there's
time.
somebody
sir.
coming up. That's
Yes. Morning, Mr. Chairman and members of the committee. I'm Brian Haskins, Pennsylvania County Commonwealth Attorney. I'm here speaking on behalf of VACA. VACA is opposed to the bill. We have reached a consensus opinion that the sealing of major felony marijuana distributions, particularly super large quantity distributions that remain illegal, is against what we would consider public policy. Thank you.
And so, Mr., you were opposed to the policy that was passed last year? the
We're
underlying
opposed to
policy.
sealing, we remain opposed to sealing
Okay.
significant felony offenses
Okay.
like
Thank you so
large-scale
much.
distribution of marijuana. That is the substance of our opposition to this bill. Thank you, sir.
Thank you so much. Is there anybody else?
Pennsylvania.
There's nobody else. The bill is before the committee. Okay, motion is to report and re-refer to finance. Is there a second?
Second.
Okay. Are there other motions, further discussion? All in favor, vote yes.
Ayes 9, no 6.
Ayes 9, no, vote no 6. The bill goes to finance. Senator McClellan, you're next. Senate Bill 483. Do I have a motion to adopt the substitute? Is there a motion to
So
adopt? So moved. Is there a second? Is there a second to adopt the substitute? Second. All in favor of adopting the substitute, say aye.
Aye.
Okay. Any opposed? The substitute's before you. Senator McClellan.
All right, thank you, Mr. Chair. This is a bill we heard, I don't know, last week, I guess, that does two things. The first remains in the substitute, basically removes the statute of limitations for civil suits brought for sexual abuse of a child and has a revival window against people in the substitute version to fix a constitutional issue. The second part with the substitute now creates a working group at the Department of Education to review and make recommendations on training and background checks for basically sports groups that would be interacting with children to address and prevent sexual abuse in the future. So rather than putting any requirements in place now, just ask the Department of Health to develop a work group to make recommendations to this body.
So the bill is significantly altered, but
Yes.
do I understand that you still have taken the cap off the 20-year statute of limitations to make it a lifetime? There's no limitation on a cause of action
For civil actions,
for
correct?
civil action.
Yes,
So you're essentially treating a civil action the way you would a felony
yes,
in this instance.
yes.
Okay.
Mr.
Other
Chair.
questions for Senator McClellan? Senator Peterson?
Yeah, and I want to thank Senator McClellan's changes regarding the youth coaching. And let me just, I want to make a point, having been active in youth athletics for over a decade, how hard it is to find coaches and how much youth participation has gone down, and really since my childhood. And any obstructions, I mean, I can just tell you again from coaching, there's so many certifications you have to go through that I just beg people to please talk to coaches before they pass any laws. And I recognize she's pulled back on that, and I thank her for that. And I'll just leave it at that. I'm sure I'm still not a fan of the bill because of the statute of limitations cap, but I do want to recognize her for that.
There were two issues last time. One was the work group that now is addressing the coaching issue. The other was the statute of limitations.
Yes.
Whether you're going to increase it a number of years or increase it, just remove it completely.
And we did hear extensive testimony. I just will remind the committee that often children who have been victims of this abuse, it takes many, many years. I've seen a study that says in some cases as many as 50 years before they are at a place where they can deal with coming forward and reporting. And so just as we don't have a statute of limitations for the felony, this then gives them the ability to move forward with a civil suit rather than taking on the burden of all of the therapy or whatever costs that they may have had to have incurred going forward.
Senator McClellan, do you know of another instance where there's no statute of limitations at all for civil action?
Off the top of my head, no. Charles is saying no, and I would again just say that the trauma caused to children who have endured sexual abuse is very difficult to overcome. And it's a question of, do you want to shift the burden of the healing associated with that to the perpetrator or leave it on the victim?
Okay, very, very good.
Yes.
Mr. Chair.
Are there other questions for Senator McClellan?
Yes.
Senator Peake?
Thank you, Mr. Chairman. Senator McClellan, so if the statute of limitations is now uncivil, unlimited, I mean, can they bring suit again after you're dead against your estate under this?
Yeah.
Yeah. Wow.
I mean, I theoretically, I think it'd be pretty hard to prove anything.
It's going to be hard to defend it again.
Especially if we repeal the dead man statute.
Yeah, I have a question.
Senator Edwards?
I still have a problem with the no statute of limitations. 11 or so years ago, when I chaired the Civil Law Subcommittee, we spent a lot of time, enormous amount of time on this very issue. We increased it to 20 years from 18. Now, I don't have any problem with increasing it further, but there's a reason for the statute of limitations. It's not just for the defendant, but for justice. I mean, memories are foggy, memories, people die, memories are gone. I mean, it's for repose as well as for the idea of making sure justice is done, that you have people that have some fresh memories of what happened. And so I have a real problem with just saying no statute of limitations.
Mr. Chair, if the committee would be willing to just extend it an additional 5 years, I would
Do I hear a motion?
take that as a
I'll take that.
improvement.
I'll make that motion.
Senator Edwards makes the motion. Right, yeah, it does suspend it forever. Look at D1.
So go from 20 to
D1.
25.
Okay, got a motion to take the statute of limitations, extend it 5 years.
Mr. Chairman.
It'll be 25 years.
So Senator Obenshain.
So to Senator Peake's point, it still could be an action against an estate.
It still could, I mean, like it could be now if it's under 20 years.
Right. Can I raise a point?
Senator Peterson.
And I voted against this bill, frankly, 12 years ago, so I've never been a fan of it. But as I recollect, if you allege repressed memory, you can even get around the statute of limitations. I think that's the case. Yes, Scott's not, yes, I mean, I've litigated these cases. If you allege and bring a psychiatrist or psychologist to court and say he repressed or she repressed the memory, you can avoid statute of limitations altogether. That's current law.
Senator Edwards made a motion to impose an extension of the statute of limitations from 20 to 25 years. Is there a second on that motion?
Second.
So there's a second. All in favor, say aye.
Aye.
Opposed? No. Okay, the statute of limitations goes from 20 to 25 years.
Mr. Chairman, is that the one on line 50?
Excuse me, Senator Morrissey.
Yeah.
You have a question?
Mr. Chairman, it would be on line 65 of the substitute, strike at any time without limitation and insert within 25 years.
I have a question.
Well,
Senator
I
Morrissey's
think-
got a question.
I think you,
First question, very narrow one. Can you distinguish between the words during the infancy of the person, what specific age that refers to? And I'm looking at the original.
below 18.
What's that answer?
Below 18, younger than 18.
Okay. So help me get around this. I understand what you're trying to get at and allow a lawsuit against somebody who was sexually abused. But the reason for a statute of limitations is because there is an acknowledgement that after a certain period of years, memories fade, people die, witnesses cannot be located, and we don't want other people to jump on board a lawsuit that they suffered no injury. I'm concerned about those people, whether it be coaches or teachers, Catholic priests, it doesn't matter. Some have to have some period of time so that we can, that's finite, that allows the person to defend themselves and not have that lack of memory affect the outcome of the case. That's what I wrap my head around.
Mr. Chair, I understand that concern, which is why I suggested the amendment to just extend it 25 years. But here is the reason for the bill. Here's what the witnesses that came testified to. Here's what studies have shown. When children have been sexually abused, it often takes many years, more than 20 in a lot of cases, before they are psychologically, emotionally prepared to move forward and bring charges against their accuser. Time and time again. We have seen, even with the allegations against the Catholic Church, for many of those people, it was 50 years before they were ready to move forward. There is no statute of limitations for a felony. So you could bring criminal charges against the abuser.
Bad person.
Well, let me finish. And yet you could not recover damages for the trauma that you have incurred, even if they're convicted in a case brought 30 years later. This bill is seeking to address that.
Follow-up question.
Senator Morrissey.
I fully understand that, and you made a very good point. What about a situation where it's a hospital and they use some type of procedure that 20 years later is clear to everybody it was horrifically flawed, or a drug that was used that is clear it was terribly flawed? We don't allow, we have a statute of limitations because we want to have a finite period wherein you can bring suit. What would be the difference between a child who 25 years later realizes, I was assaulted, versus a hospital where a quarter of a century later, the procedure for delivering the child was horribly flawed and should have been apparent? Why not allow an extension in that as well?
If someone wants to bring that bill, they can. I am bringing this bill forward on behalf of survivors of child sexual abuse. And I think given the amendment and the constitutional issues raised about going after an institution after the statute of limitations has expired, that's part of why this wouldn't be against a hospital. It's just a policy decision for this committee.
Mr. Chair.
You've got Senator Peterson.
And again, I apologize for speaking twice. I think there's a couple things people need to be aware of. Any cause of action involving a child does not accrue until they turn 18. Okay, so it doesn't even begin to accrue till then. So the current law means until you turn 38, you have the cause of action. Now, if you allege a repressed memory, you can even extend it beyond that. So, theoretically, it's indefinite right now. But you have until age 38. That's the current law.
And this would take it to 43.
And this would take it basically to 43.
Okay, I think we understand. Are there people here? Well, we've already heard this bill. We've already heard the evidence on this bill. So the bill is before the committee.
I move.
We made the amendment that takes us 5 years.
I move that the bill as amended be reported.
Okay, Senator Lucas made, Senator Edwards made, Senator Lucas. Are there further motions? Are there further discussion? All in favor of reporting the bill? It's referring to finance.
Yes.
Say aye.
Aye. Right, vote aye.
Vote aye. Okay,
Ayes 7, noes 8.
Ayes 7, noes 8. The bill fails to report.
Mr. Chair, if the committee if the reasons for the votes is on the statute of limitations piece, I would be willing to strike that from the bill and move forward with the work group.
I move to reconsider the vote.
Well, it's still in the body of the committee, I think.
You have to vote.
We still have to vote to reconsider the vote.
So, yeah.
I move.
Yeah, we don't need a legislation.
Well, that's fine. I mean, if you wanted to do it with the letter, that's fine, but I at least want that piece of I want the work group to move forward however way possible.
Mr. Chair, I respect, I don't want to reconsider because the policy choice is the policy choice. I do think it's incumbent on, we could do a letter.
That's fine.
Yes.
Okay.
I'll make the motion that we pass the bill by indefinitely with a letter to which agency?
Department of Education.
To the Department of Education to convene a work group. I'll make that motion.
No, the motion failed.
Yes.
So the bill's still in the body.
Still in the breast of the
I
committee.
move to reconsider.
No.
The vote.
We don't.
Well, it failed.
Senator Peterson has made a motion to PBI.
Motion to PBI with a letter.
The Department of Education, is there a second to that motion?
We don't need to.
That's not an appropriate
That's
motion.
an appropriate motion, yes it is.
It's failed.
It failed to report.
Yeah.
So there's another motion is in order.
I need a second, guys, to PBI. All right.
Send a letter.
Okay, motion to PBI with a letter. All in favor of that, say, vote aye.
I don't think we voted.
It's a motion to pass by indefinitely with a letter. Okay.
Ayes 11, noes 3,
You've got
1
another-
abstention.
You've got another bill, 658.
I do.
This one doesn't have to go to finance.
No. So 658 will clarify language regarding the storage and destruction of PERT kits that are not sent to the Office of the Medical Examiner, and there is a substitute.
Okay, do I have a motion on the substitute? Motion and a second to adopt the substitute. All in favor, say aye. Aye. Okay, the substitute's for you.
So under current law, PERT kits have to be referred to the medical examiner's office within a period of time. There are some exceptions that mainly have to do with if that law enforcement agency is not seeking charges. What this bill does is say that if a local law enforcement agency takes over responsibility for the investigation, and and has not sent the perk kit to the Office of the Medical Examiner, the original agency that collected the information will send it to the agency that has taken over the investigation within 60 days. That's the first part of the bill. And then the second part of the bill deals with storage of those perk kits.
Stored for 10 years after the minor becomes an adult.
Yeah.
Mr. Chair.
Senator Morrissey's got a question.
Senator Lewis would have the benefit of benefiting both the victim and the defendant who was convicted. Is that right?
That's right.
We all know that physical evidence recovery kits, years after a defendant has been convicted, are often sought to be reexamined because of advancements in DNA, and this would benefit them as well, right?
Yes, because sometimes they would show that they would exonerate the defendant.
Thank you.
So do you understand the bill, or are there questions for Senator McClellan? Are there people here in favor of the bill? You got 2 minutes.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised in the
Are there
Zoom.
people opposed to the bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised
Yeah,
on the Zoom.
what I will say, Mr. Chair, is this was developed by a stakeholder group that included the Department of Forensic Science, the Sexual Assault Kit Initiative, the Sexual and Domestic Violence Action Alliance, and the Virginia Victim Assistance Network. And the state police and the Sheriff's Association have not taken a position.
So lots of input. Does everybody understands the bill? The bill's before the committee. Move to report. Is there a second?
Second.
Okay. Are there further motions? Is there further discussion? If not, please open the roll. Vote aye if you're in favor of the bill. Okay, the bill doesn't have to go to finance.
Ayes 14, no zero.
Ayes 14, no zero. The bill's reported. Senator Lucas, you're next. Senator Lucas has Senate Bill 564. If this is reported, it needs to go to finance.
Thank you, Mr. Chairman. First thing I'd like to do, Mr. Chairman, is offer a substitute.
Move the substitute.
Is there a second? Second. Okay, all in favor of the substitute, say aye.
Aye.
Okay, the substitute before you, yes, ma'am.
Thank you, Mr. Chairman. The change in the substitute from the original language, first of all, is the auto expungement process is initiated by state police pursuant to Virginia Code subsection 19.2, that's 392.7 parentheses A. Virginia State Police identifies qualifying offenses within the CCRE system. In turn, they notify the courts which records should be sealed. Are you still waiting?
We're listening.
Okay, therefore, if VSP cannot identify the records as described by the bill, they will not be able to notify the courts. The first issue is only offenses listed in Virginia Code subsection 19.2, that's 390, are reported to CCRE pursuant to subsection 19.2, 390. The offenses listed on lines 24 through 27, and of course list those sections of the code, are not reportable to CCRE, which means VSP will not be able to identify these offenses to the court for automatic sealing. Number three, on the probation violation piece, we're willing to move the related probations violations piece into the petition-based bucket, which seems like it would take care of OES's concerns, since the petitions would be able to be included in the related charges and would be known to the court then for consideration. Secondly, Mr. Chairman, misdemeanor probations, violations, revocations, hearings, probation violations also should not be in the CCRE, since only felony probation violations are reportable to CRE as of a year or two ago. Now, the enactment clause number 2 of the sealing bill last year said that VSP is to delete all records from CCRE that are not required to be reported to CCRE. As such, VSP should not have any misdemeanor probation violations in CCRE and would not be able to identify probation violations from misdemeanors to be sealed as directed in lines 21 through 23.
I guess the group that looked at these bills had some problems with the original bill as written, but those problems have been alleviated by the substitute. Is that correct? The problem that was on the original bill, lines 24 through 27, is that change was fixed in the substitute?
That's correct, Mr. Chair.
Okay. Are there questions for Senator Lucas?
Mr. Chairman,
Senator Serville?
I think your explanation, Senator, had more to do with the substitute and the differences between the sub and the original.
That's correct.
But the bill that's in front of us still takes it from, instead of a 7-year waiting period to get an expungement, down to 3 years. And it also says that the two sealing petition, the existing law says you can only seal 2 offenses in your lifetime. This basically makes it unlimited, right?
That's correct, Mr. Chair.
Okay, and Mr. Chair, one other
Senator
question.
Serville.
I assume the senator, I believe, was with us when we did it, but all those compromises were sort of heavily and significantly negotiated compromises between the House and the Senate in order for us to arrive at a consensus last year, right?
That's correct.
Okay, and I guess we're trying to undo that now.
That too is correct.
All right.
Okay, are there additional questions for Senator Lucas? With 2 minutes for people that are in favor of the bill. Are there people in favor of the bill?
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Good morning, Mr. Chairman, members of the committee. Michael McMillan with Justice Forward, Virginia. We support this legislation. Anything we can do to remove the barriers around expungements is a good thing to do. I would highlight especially the fee removal provision. Money, someone having money, someone not having money should not be a barrier to obtaining this relief. Thank you.
And you would agree that we addressed that to some extent in Senator Serville's legislation?
Mr. Chairman.
Hey, apparently not. Yeah, Senator Serville.
My recollection is that we funded the court-appointed attorney program for sealing and expungement by using the fees that I guess this bill gets rid of. So we would now, I assume, be funding this with general funds instead of the fees paid by people with lawyers, right?
Is that the intent of the legislation, to do away with the fee that pays for the court-appointed lawyers?
Where does it say that? Where does it say that?
Mr. Chairman?
Senator Serville.
Well, it doesn't say that, but the money got to come from somewhere, and the fee fund, the court-appointed attorney fee fund last year was funded with the fees paid by people with retained counsel. And so I'm assuming, given we're getting rid of that fee, the only other way to fund this would be with general funds, unless there's a budget amendment that I'm not aware of that would fund it in a different way.
Okay, are there other people in favor of this legislation that need to speak?
Mr. Chairman, there are 8 people on the Zoom who would like to speak.
Okay, 8 people, you've got 1:40 between you, so I'd ask you to keep your remarks very brief.
Sean Winetta, would you please unmute and begin your testimony?
Thank you, Mr. Chair. Sean Winetta on behalf of the ACLU of Virginia. We are in support of this bill.
Okay, thank you, sir.
Rob Pogan Class, would you please unmute and begin your testimony?
Yes, thank you. Mr. Chair, Rob Hogan Class from Legal Aid Justice Center. We strongly support the expansion. A conviction in Virginia stays public forever. The record sealing law passed last year will finally change that, allowing people who have proven they can go several years without a new conviction a chance to remove old criminal records from public view. This bill would expand on this ideal by eliminating the lifetime limit and reducing wait times. This bill will remove significant barriers for hundreds of thousands of people. Urge the committee to pass the bill. Thank you.
Thank you, sir. Next.
Martez Talbert, would you please unmute and begin your testimony?
Good morning, everybody. My name is Martez Talbert. I'm the Director of Client and Community Engagements here at the Fountain Fund, Charlottesville, Virginia, and we do support this bill.
Okay, thank you, sir.
Got a number of clients that would love for this bill to be supported. So thank you guys for having me this morning.
Thank you very much.
Sheba Williams, please unmute and begin your testimony.
Yes, good morning. My name is Sheba Williams, Executive Director of No Left Turns. We strongly support this bill. We know that two sentencing events does not cover when a person has substance use disorder or many other times when they're going through challenging times in their lives. So we strongly support this bill. Thank you.
Okay, thank you, ma'am. Next.
Johannes Whittaker, would you please unmute and begin your testimony?
I'm sorry. Yes, my name is Whitmore Merrick. Thank you for letting me speak. And we urge to support the 564 bill in representation of the Virginia Expungement Council. And I'm sorry.
Okay, we're out of time, so just identify yourself, and if you represent a group, you can identify that group as well, please.
Yes, the Expungement Council. My name is Whitmore Merrick. Thank you. And we urge to support.
Thank you so much.
Valerie Slater, please unmute and begin your testimony.
Valerie Slater, representing NAACP and Rise for Youth. We strongly support this bill.
Okay, thank you, ma'am. Next.
Linda Brown, please unmute.
Good morning, Linda Brown, and I strongly support this bill.
Okay, thank you, ma'am.
Richard Walker, please unmute.
Executive CEO of Bridging the Gap, Virginia. We strongly support this bill to help countless individuals that have proven themselves over the years.
Thank you, sir. 2 minutes for people that are opposed to the legislation.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised at this time.
Okay, we've got one person in the room.
Mr. Chairman, members of the committee, I am again Brian Haskins, Pennsylvania County Commonwealth Attorney, speaking on behalf of VACA. We are opposed to this bill for a particular reason, and that is the reduction of the time to 7 years in the bill, because we are also dealing with Class 5.
So 7 years to 3 years.
7 years for a felony.
To 3
which
years.
Applies also to Class 5 felonies, which are up to 10 years imprisonment possibility, and therefore an individual who could be on probation or good behavior for that Class 5 felony can have his conviction sealed while they're still on probation or good behavior by the reduction of this time frame. And that's the significant issue that VACA has with the bill.
Okay, thank you very much.
Question of,
Senator
Brian,
Morrison.
what is
Yes,
your
sir.
last name, please?
I'm sorry?
Your last name, please?
Haskins. Yes,
Haskins,
sir.
I
From
thought.
Pennsylvania County. Thank you, sir.
Mr. Haskins, one of the main reasons, the genesis of this bill is that stigma that applies for 7 years prevents people from getting jobs. Forget about housing opportunities or education, just jobs. Why isn't it a good thing to promote, to reduce it to 3, allow these people to get jobs, and therefore, since there's a direct connection between employment and lack of being a recidivist, why isn't that a good thing?
VACA takes no position on the assisting individuals. I'm sorry, Mr. Chairman, Senator Morrissey. VACA takes no position on an individual being able to get a job. We don't oppose that portion of the bill. What we are concerned about is the impact on law enforcement and our ability to enforce court orders when an individual has their conviction sealed while they're still in either probation or good
Yeah,
behavior.
he's basically saying that somebody can be on probation and get a sealing at the same time. That's his concern.
Follow-up
Senator
question to staff. If it's sealed, whether it's sealed or automatically sealed, are law enforcement agencies prohibited from seeing that sealed record if the purpose is to determine if they are in violation of a court order?
Mr. Chair, there are numerous exceptions to what records that are sealed are available, and I believe one of the exceptions would make those sealing records available to law enforcement.
Follow-up question. Mr. Haskins, given that law enforcement would be able to see those records and it would be available for the purpose, does that change your position?
Mr. Chair, Senator Morrissey, no, it doesn't change VACA's position because our position is that the sealing creates a difficulty for agencies outside of the one that prosecuted the crime to access that record or even know it exists.
I think if you said that a person on probation couldn't get the sealing, I think that would remove VACA's opposition.
Can I ask a question?
Senator Peterson.
Okay, I have a slightly different scenario, and that is, let's say you hire somebody to look after your parents or look after your in-laws, or maybe you hire somebody to manage your accounts if you're a business. And this person may have an embezzlement. They may have some type of financial crime. How are you able to protect yourself? I mean, that's the scenario I'm more focused on. It's not just what the public's.
Certainly, Mr. Chairman, Senator Peterson, as I understand the sealing would allow law enforcement to have access to that information. For example, if I prosecute someone for an embezzlement or for a check fraud, for example, forgery of a check from a previous elder person they were working for, and the person moves on to another employer, I would not be allowed to disclose that information.
Further question, Mr. Chair.
Senator Peterson.
So in other words, let's say I'm hiring someone to be a caretaker for my parents, And I said, I really want to do a criminal background check. They'll be alone in the house. They'll have access to maybe some financial accounts. They would not, and I know we've got the law right now at 7 years, so it would now be down to 3 years.
Yes.
Senator Serville.
Mr. Chairman, just so we're clear about a couple things. The law that was passed, which isn't effective until 2025, and is currently subject to like a $20 million procurement with about 10 different people at state police working to develop the computer system necessary to do this, and it's all in process based on the law that we passed. That current law says that certain employers can get access to sealed charges. The Virginia State Police was required to promulgate regulations identifying which types of jobs could look to seal convictions. They haven't promulgated the regulations yet, but the idea was that there were jobs that people would be in sensitive positions or have access to sensitive information like money or whatever, where they might be able to access that, but the list hasn't come out yet. So the answer is your parents might be able to access it, but the regs haven't come out to clearly identify that yet. But it sounds like the kind of situation where we would allow that. But I would just note, Mr. Chairman, that the policy behind the 10 and the 7 years was to identify a conservative period of time because we didn't have time to look at a lot of science behind when people are likely to recidivate. And so we intentionally picked timeframes that were kind of longer than I guess Senator Lucas would like to be safe.
I was in the room
You were
too.
correct.
Okay, does everybody understand the bill? Thank you, Mr. Haskell.
Thank you.
Does everybody understand the bill?
Would
If
you
there's a
entertain a
motion to
motion
report,
at
it
this
has to be
time?
re-referred to finance.
Would you entertain a motion?
Well, if you've got a question, I'm ready for a motion, yes.
Motion, move to report.
Report and re-refer to finance. Got a motion to report and re-refer to finance. Are there other motions? Is there further discussion? If not, open the roll. If you're in favor of reporting, re-referring, vote yes.
Ayes 7, no 6, 1 abstention.
Thank you.
Okay, the bill's reported and going to finance. Senator Stanley's got 2 bills next, and I guess he's not here? Okay. I guess people that are worried about the medical malpractice cap and the civil health actions, health bills and records, those bills are just gone if Senator Stanley's not here. Senator Peterson's got 2 bills next. 664. Stanley's not here, so Peterson.
Okay.
I've got your bill next. Or no.
Thank you, Mr. Chair, members of the committee. This is Senate Bill 664.
Yeah, that's fine.
Okay.
And like most good ideas, it didn't come from me. It actually came from a constituent. And I believe there's a companion bill in the House. And basically, this has to do with minors who are prosecuted for prostitution. Typically, they've been in a trafficking situation. And under 18.2-347, this would amend the code that's saying any minor who engages in conduct, which again references the bawdy place, which is the prostitution statute, and that should be shall not be prosecuted, or it says shall not be proceeded upon as a delinquent. I'll defer to my learned counsel, Mr. Benjamin. That's the right language. I thought it maybe as prosecuted, but shall be referred to the Department of Social Services for an assessment pursuant to 36.2-1506.1. The bottom line is these are young children, typically girls. Typically they're either in very dire straits personally, or they've come into this country, without papers, and they're forced into this situation. And the point is to not have them prosecuted through the criminal justice system, but rather than to refer them to social services.
Okay, so the whole idea is here, if a child is engaged in prostitution, you would refer them to the Department of Social Services instead of charging them with crime?
Yes, sir. And my question is whether the word proceeded upon is the correct verb, or whether it should be prosecuted. I don't practice.
Mr. Chair, since these are delinquencies and not criminal prosecutions, proceeding is how we use that term in the code.
Okay, well then, there it is. All right.
Okay, Mr. Qualiado's
Okay.
answered the question. Are there questions for the patron?
Mr. Chairman.
Senator Obenchain.
So, I mean, are there other crimes that these minors can be prosecuted for?
Sure, theft.
Mr. Chair, I'd answer yes. Any of the other offenses that they may be engaging in, they could be, proceeded upon as delinquent.
Mr. Chairman, for the
Senator
question. And I've carried as many human trafficking bills as anybody in this body, and I have a real heart for trying to protect victims of human trafficking. And I've always understood that this is a tough issue. I don't know that there are any prosecutors or in Virginia who look to prosecute these children, but if you look at human trafficking, a lot of these children don't view themselves as victims. They may be 15 years old, but they have been cultivated and may like some of the benefits that they get, but they are children. And sometimes the only way that some agencies are able to, get these children help is, by placing charges in order to, leverage them into accepting services. And, I've talked to a lot of prosecutors and a lot of advocates for human trafficking victims who, don't want any of these kids truly prosecuted, but they also want them to accept services. So, I'm deeply conflicted about this.
Okay, Senator McDougal.
Mr. Chairman, I guess two questions. One is not proceeded upon as delinquent. That's not going to prohibit a CHINS petition along the way? And I guess that's more to Charles.
No, Mr. Chair, that should not prohibit a CHINS petition.
Okay, Mr. Chairman, but the other question I would have, I think along Senator Obenchain's line of question is for the Commonwealth's attorneys. Is this going to impede the ability to get the people that are the actual bad people that are forcing them in this direction if they can't be prosecuted on? And I'd like to just hear what they have to say. Because I think we all agree with Chap's position that these are not individuals that you want to criminalize, but does that have a negative impact on the ability to prosecute?
Mr. Haskins, do you have a?
Sure.
Again, Brian Haskins, Pennsylvania County Commonwealth Attorney. I'm speaking on behalf of VACA. VACA has not taken a position on the bill. To speak to the exact question that Senator McDougal is asking, Senator McDougal, I don't think that it would prohibit us from being able to prosecute those individuals. The difficulty in prosecuting these individuals is not that a child is going to say, I want to plead the fifth, because we would give them immunity if we wanted to go after an individual. And frankly, I don't know a great deal of prosecutors who would want to prosecute a child for being sex trafficked to start with. I'm not aware of any. I've certainly never done any myself. But the difficulty that we see is overcoming that relationship that the individuals have been groomed to accept their abuser, their handler, their pimp, for lack of a better way of putting it, as the individual who is pushing them out there and telling them this is a good life and this is your only life. The difficulty is overcoming that bond that they reach and get them to be willing to testify. Whether we have this charge or not ability, I would submit does not greatly impact our ability to go after that individual, because we have to break the bond and not threaten them with a charge to get them to testify. If they have that bond, we can threaten them with a charge to testify. They'll never testify. They'll just take their misdemeanor time. This also, if it's okay, as a personal matter, as a Commonwealth attorney, I'm in favor of what this bill is trying to do, because we don't want to try and prosecute young people who are being trafficked, perhaps even willingly at this stage, but have been groomed into that practice. I hope I answered your question, sir.
I'll take that as an endorsement.
Thank you, Mr. Chairman. That's
Has
that's
the
exactly what I
Department
was
of
looking
Social
for.
Services made any, have you had any contact with the Department of Social Services about this bill?
No,
Senator
sir.
Peterson? You don't know what?
Not that I know of. Maybe my office has. I have not.
You don't know whether they can take on this?
I got it.
Mr. Chairman, if I can ask a follow-up question, the charge of Child Protective Services, I think, or Department of Social Services, is to handle cases of abuse or neglect. So, and my understanding is that that has been one of the serious problems with these cases, is that sometimes in some agencies, Department of Social Services is called and they say, I don't see that this child has been abused or neglected, and they refuse to provide services.
I don't see, if a child is picked up for prostitution.
How could you
I
not?
agree.
I don't see how you could not.
I'm just telling you,
Okay.
they have refused to do it.
Well, then
So
we need to write a strong letter and tell them to do their job.
I have a question.
Senator Edwards.
Senator Peterson.
Yes, sir.
We already passed last year, I think, an affirmative defense for children, for people who have been abused like this. And what's wrong with just leaving it at that? The affirmative defense that we passed last year, I believe we passed it, that that they were dragged into this trafficking situation. Is that true, Charles? Didn't we do that last year?
Mr. Chair, I know we passed a writ of vacatur, which would allow convictions to be vacated last year, 2 years ago. I'm not certain that there was a affirmative defense.
Yeah, I'm not familiar with that.
But I think to Senator Peterson's point is, he doesn't, the intent of the bill is to divert the children even before they get into the criminal justice system or the juvenile justice system. It's to divert them immediately to get social services and not juvenile services
Is there any
as
opposition?
delinquent.
Is there any opposition to the bill?
Well, Senator Stewart's got a question.
Thank you, Mr. Chairman. Chap?
Yes, sir.
This is not my area of practice, but I thought that the juvenile intake officer already had this ability to do this, to transfer juveniles before they actually got into the criminal system.
Well, they certainly have the ability. This would make a shall.
So that's my question. Is there any evidence that we need to make it a shall, that giving them the discretion on a case-by-case basis isn't working?
Well, if your answer, do I have witnesses on that? No, I don't. And I think, again, this is a statement where I would think 95% of the time they would do so. To me, it's self-evident that you don't want to prosecute this child, but again, that's...
Mr. Chair, I'll maybe I can throw a lifeline.
Okay, help.
There is a provision that says the intake officer may proceed informally on a complaint alleging a child's in need of services, but only when the juvenile is not alleged to commit a violent juvenile felony, which doesn't apply here, but has previously not been proceeded informally or adjudicated delinquent for an offense that would be a felony if committed by an adult. I would tend to think that some of this target population may have picked up some prior criminal offense, which may prevent such informal diversion.
Okay, are there people here to speak in favor of the bill?
For those in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
2 minutes.
Patrick McKenna, would you please unmute and begin your testimony?
Mr. McKenna.
Patrick McKenna, would you please unmute and begin your testimony?
Thank you, Mr. Chairman, members of the committee, supporting staff. My name is Patrick McKenna. I'm the president co-founder of Human Trafficking, Justice and Freedom International, also a member of the Virginia Coalition Against Human Trafficking. This bill is needed. Well, let me just say this. First of all, the bill requires law enforcement to do what they should already be doing under our definition of child abuse within the state of Virginia. And accordingly, they are mandatory reporters. So a child participating in any way, whether voluntary because of survival, sex, say, or because somebody is forcing them into doing it, should be immediately proceeded upon because our as a victim of child abuse in Virginia, period, end of statement. To speak to Mr. Chairman, to speak to Mr. Senator Obashane's point earlier, social services is now mandated to perform an assessment when a child is identified as a victim of human trafficking under the federal definition. And they're also able to hold them up to 72 hours. What this bill does then is notify and remind law enforcement that they should be doing something that they're already mandated to do under the statute. And the problem is, in the last 2 years, there have been at least 2 prosecutions for prostitution in the state of Virginia. So it's a mindset that we're asking law enforcement to take, as opposed to a prosecutorial mindset, as one of treating this child as what they are, a victim of child abuse.
Thank you so
Thank you,
much.
Mr.
We've got
Chairman.
about 30 seconds left for the rest of the speakers, so please identify yourself and any group you represent.
Cindy McCoy, please unmute.
Good morning, Chairman and members. My name is Sydney McCoy. I'm the president of the Virginia Coalition Against Human Trafficking, as well as Policy Counsel with the Mara Legal Center, which is a nonprofit that provides free legal services to victims of trafficking. We support SB 664 and urge its passage.
Thank you, ma'am. Next.
Valerie Slater, please unmute.
Valerie Slater for Rise for Youth, NAACP, and Human Rights for Kids. We strongly support this bill.
Thank you, ma'am. Yes, next.
Sarah Benston-Duhow, would you please unmute?
Hi, good morning, Chairman and committee members. Sarah Benson with Shared Hope International. I'm an attorney here and also representing the coalition. We are in support of this bill. We're also the only international group monitoring anti-trafficking legislation, and safe harbor laws have proven to be one of the most promising practices.
Thank you very much. Who's next?
Priska Bijani, please unmute.
Good morning. My name is Priska Bijani. I'm the director of Libertas Home, which is a nonprofit organization in Northern Virginia and also a member of the Virginia Coalition Against Human Trafficking, and we support this bill.
Okay, thank you very much. Who's next?
Megan Gerbach, would you please unmute?
Yes, hi, my name is Dr. Megan Gerbach. I'm a clinical psychologist and board member for Reset 180. We work with survivors of human trafficking and also a member of Virginia Coalition Against Human Trafficking. They absolutely support this bill on
Thank you very
behalf
much.
of all the victims I work with.
Are there people that are in opposition?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised at this time.
Okay, Senator Morrissey's got a question.
Senator Peterson?
Yes, sir.
First of all, to relieve any anxiety, I'm going to support this bill. But I have a question.
Yes, sir.
Most of the comments so far have dealt with sex trafficking or human trafficking. Are either of those words mentioned anywhere in this legislation?
Well, no, I mean, it could be any minor, so it could be someone who ran away from home or, yeah.
Follow-up question. It doesn't say any minor who engages in conduct prohibited by this section and is a victim of sex trafficking. It just says any minor. So let's be clear. If you're a minor and you're involved in this activity, you go to social services.
Right.
I just have a problem with every time we have legislation like this, we wrap it in the mantle of sex trafficking or human trafficking. I was won over by minor. Okay?
Mr. Moore, Senator Moore, you're completely right, and it was my advocacy, which tends to kind of, go for the phrases which will get the most sympathy from the panel, and so you caught me. Busted. Busted.
Move to report. Is there there is a second? Are there other motions? If not, please open the roll. Vote yes is a vote to report. Okay.
Ayes 11, noes 3, 1 abstention.
Okay, your bill is reported. You've got Senate Bill 665. If that's reported, it has to go to finance.
Yes, sir. And yes, sir. Thank you, Mr. Chair. And I'll say right now, this is another constituent request that was brought to me, and I don't typically bring bills that increase criminal penalties.
And this basically just says there's a specific manslaughter case tied to reckless driving.
Right. And I'll give you the example. If someone is driving at a reckless speed, let's say over 90,
Right.
and they T-bone another car, which is exactly the situation that happened and affected my constituent, and then somebody dies, that would be treated as, it could be treated as an involuntary manslaughter.
Okay.
And it is what it is. I mean,
There's nothing
Chairman.
that says it can't be treated as involuntary manslaughter now. It's just.
That's true.
Mr. Chairman.
Right.
Senator McDougal.
Mr. Chairman, Senator Peterson, so I just want to be clear. If you're driving 86 miles an hour, you could be convicted in a 70 mile per hour zone. You could be convicted of involuntary manslaughter with this change. Because the only requirement is that it be reckless driving.
Well, it has to be the sole and proximate cause. I mean, it could be, you could have lost control in a range. I mean, it could be any number of, but.
Mr. Chair.
Senator Survell and then Senator Morsi.
Thanks, Mr. Chairman. And I understand what the senator's, speaking of the bill, I understand what the senator's reacting to. I mean, I think in the 13 years I've been here, I think this is like the third time or fourth time I've seen people trying to turn any traffic infraction, or obviously this is reckless driving, but that causes a death into a felony, whatever. And the reason we don't do that is because it doesn't work. Typically,
Do you have a question or you just want to preach?
No, I'm explaining the problem with it. The problem is that the victims can often be eggshells. I mean, one collision might cause a death, another collision might just cause somebody to walk away. The technology of the car makes a difference. The physical condition of the victim makes a difference. We premise punishment based on the conduct of the person who did the offense, not on the outcome to the victim, typically in traffic cases. And so, we always have these sympathetic cases where, a collision occurred and somebody died and somebody thinks it should have been a felony, but it doesn't work in practical application. And so I appreciate the motivation, but it just doesn't work legally.
Okay, Senator Morsi.
Senator Peterson, I'm not going to preach, and I'm not saying that to be dismissive of Senator Serval, but you've said that if a person is convicted of reckless driving, death, it results in involuntary manslaughter. I want you to understand that involuntary manslaughter is the accidental killing of another individual during the commission of a lawful act. Accidental, lawful act. I want you to also understand that reckless driving isn't just going 90 miles an hour. Reckless driving, as our prosecutor will tell us, includes breaking traction with the ground. Gravel, for example. It could be going 45 in a 20. It could be that 70-year-old lady who's coming home from church on Sunday and does something slightly more than improper driving. It's reckless driving, goes through that red lights and kills somebody. The problem that I have with this legislation is that it captures those people who ought not to be convicted of a felony involuntary manslaughter because they've been convicted of a minor category of reckless driving. That's why I'm going to put up red.
Another preacher. Senator Saslow.
Just a question to Senator Morrissey or you. That NFL football player in Las Vegas who was driving 155 miles an hour and crashed into the back of that car and killed 2 people, you don't think that's a felony?
Not at all. It is a felony. You completely missed, Senator Saslow, completely missed my point. I specifically said there are incidences that they should be charged with that, but there are other laws that would allow the person to be charged with involuntary manslaughter
Mr.
or
Chair, can I
voluntary
cut to the
manslaughter.
chase here?
Senator Peterson.
I didn't put in a budget amendment on this, so y'all send me to finance, I'm probably going to waste away there. So, look, you can end me here, end me there. I had a constituent that had this issue. I brought this
Okay, got a
bill.
motion to PB out of the bill. Senator Edwards has a
simple question to put the nail in the coffin here. Kind of like Senator McDougal. If you're going 56 miles an hour in a 35 mile an hour zone and you hit somebody and they happen to die, you could be convicted of involuntary manslaughter in this case.
It could be if it's a sole and proximate cause.
Yeah,
yes.
we've got a motion to PBI. Is there a second?
Second.
Okay. Are there further motions? Is there further discussion? A green light means you want a PBI of the bill. All in favor say.
All right.
Okay.
I
Okay.
did my best.
My bill 713 is going to go by for the day. We've got Senator Stanley who has two bills. I understand that there's somebody here who can present Senate Bill 633, and so you were behind the column there. I didn't know whether you were in Zoom land or Mr. Dix can present 633.
Thank you, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. We're here on Senate Bill 633. There was one line amendment which we brought to the patron, which he was agreeable to. If staff could probably read that, that'd be great.
Mr. Chairman, it's two line amendments on line 13. After bill means strike A and insert any, and then after statement, strike or summary. So it would read bill means any statement of charges.
Okay, do you understand the amendment? Is there a motion to adopt the amendments? Second. All in favor of the amendments, say aye. Okay, the amendments are adopted. Mr. Dix.
Thank you, Mr. Chairman. So Senate Bill 633 is a housekeeping matter that does two things. The first is that it clarifies, or it makes it very clear that a bill for purposes in the circuit court or in the general district court, a healthcare bill is any statement of the charges. What we're finding is that oftentimes you're getting bills not from the healthcare provider, but from their billing agents like PsyOx and some other corporations. A lot of them are not even in Virginia. And there's been kind of a quilt patchwork of decisions by judges as to what constitutes a bill or does not constitute a bill. This clarifies that and has the support of the Medical Society of Virginia. We appreciate them working with us on that. The second part of this deals with 16.1-88.2. It was a confusing statute that deals with the admission of medical bills, records, or statements in the general district court. This makes it nice and clean. In the first paragraph, it talks about a report or a statement from the healthcare provider. And then in paragraph 2, it deals with the bills or the records. And again, we just had kind of some conflicting decisions amongst the judges, and that's the bill.
Are there any questions for Senator Stanley stand-in? Okay. Does anybody feel like they need to speak on this bill?
I have a question.
Senator Edwards has a question.
In terms of who would have to authenticate the document?
Mr. Chair, Senator Edwards, so it would be someone, usually it's a custodian of records from within the healthcare provider, or if it's like at PsyOx, oftentimes they will have a self-generated form that they will sign off on. And it was because Virginia had some very specific language in this statute that we wanted to make it clear and really cut across state lines. These kind of authentication statements are the same for every state.
Well, for example, there's a case law that says the plaintiff could say, this is what I got from the doctor or the hospital.
Mr. Chair, Senator Edwards, you're exactly right. Absent this statute, you can still, a plaintiff in a personal injury action could still get bills in by just saying, those are my bills. But if the defense has a substantial defense to that, then the plaintiff has to bring a doctor. So as it is right now, even if I didn't have this, if I go in the general district court and I just have my client say, these are my bills, the bills are supposed to come into evidence. But if the defense has it's called McMunn versus Tatum is the decision. If they have a substantial defense, then the judge is going to look at me and be like, Mr. Dix, where's your doctor to prove causation? And I'm going to be stuck.
Okay, we've got a motion to report, and is there a second? Is there any further discussion? Are there other motions? Open the roll, please. Green votes, vote to report. Okay, we've got.
Pass 15, no zero.
The other Stanley bill? Senator Servell is going to stand in for Senator Stanley on the other bill, which has to go to finance if it's reported. It's a bill to raise the medical malpractice cap.
Chairman, the substitute, remove the substitute.
Okay, substitute, okay, is there a second on the motion to adopt the substitute? All in favor of the substitute, say aye.
Aye.
Okay, the substitute's for the committee. Senator Servell or Stanley.
Thank you, Mr. Chairman. The substitute basically gets rid of or it allows a judge or a jury to get rid of the malpractice cap, or sorry, it says the malpractice cap doesn't apply if a judge or jury finds there's a permanent loss or impairment of bodily function or permanent brain injury. So basically it gets rid of the cap only for the most catastrophic and permanent cases. And we talked about this last year, I believe. We heard this bill. I believe Virginia's med-mal cap is the most extreme in the United States of America. I believe there's only one other state that has a complete cap on damages like we do. Most other states just cap pain and suffering, but not medical bills. And I have two constituents who are here that Senator Stanley worked with to present the bill. One is Joe Camerata, and another one is a constituent of mine who received a permanent brain injury after a botched operation. And I believe she's available on Zoom to testify, either her or her husband, who's her
Senator
caretaker.
Norman's got a question first. Is
No,
that all right?
I have a preemptive comment on it, and we've gone through this periodically, but a number of years ago, and the individual who was involved in it with me, I realized, first of all, that things have deteriorated a little bit within the Senate of Virginia as adhering to certain commitments that we've made, and I say that respectfully. We made at least a 20-year deal the last time we confronted med-mal situation, and there was a compromise between the trial lawyers and the healthcare communities that we were not going to mess with this med-mal cap for that period of time. And
20 years.
20 years, and it just chagrins me that we come back and try to abrogate that agreement that explicitly was reached.
Mr. Chairman?
The preaching's done. Yes, sir. Do you
Well,
agree or disagree?
I wasn't part of the deal, and I wasn't in part of the conversation on the deal. I don't know whether Senator Stanley was or not. Senator Boysko wasn't even elected at the time. And so, legislatures come and go, and we run this place, not interest groups, I would just say.
Senator Sazal's got a question.
That was in 2013, or 12 or 13, and McDonald was governor.
I voted against
And
it.
the deal, so I think Senator McClellan was in elected office at the time.
Boysko, I said.
And we, after going back and forth, that was an agreement reached between, as Senator Norman said, between the trial lawyers and the medical community. And I remember McDonald had run for office, and he had made a campaign pledge that he would vote against any change in the cap, or he would veto any change. But he encouraged us to override his veto, and that put into effect, I remember specifically, he says, I expect you all to override the veto. And it was overridden by almost unanimous vote to put that in effect for 20 years, and we should live with that.
More preaching. Okay.
Then the question is, isn't that true?
Okay, so we have 2 minutes for people that are for and 2 minutes for people that are against. I would invite people that want to undo this 20-year deal to come up.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, we do have two speakers, I believe.
Okay.
Sheldon Hervey, would you please unmute?
Yes, thank you, Mr. Chairman. I'm Sheldon Hervey, and I'd like to take my 40 seconds to speak about my wife's situation. In October 2015, she went in for elective back surgery with the only fear being her back would still ache when it was finished. During the surgery, the doctor coming in from the back nicked a stomach artery, and Nancy coded for some 22 minutes before they could stop the bleeding. She could have easily died in the operating room, but she fought, survived, albeit with an anoxic brain injury. Some 6 years later, though remaining positive and working to get better a little bit every day, she's still unable to walk or perform any of the activities of daily living and remains incontinent. My once brilliant wife now struggles to remember what she had for breakfast, but thankfully remembers a little bit of our wedding day. In July of 2019, I was thankful for the favorable jury verdict in our malpractice trial, but was somewhat disheartened that due to the cap, our net award was less than 10% of the projected economic cost for Nancy's life care. Projections were not disputed by the defense attorneys because they knew they would never have to pay that amount due to the existing cap. Money's never going to change history, but the money that we have received has gone entirely to Nancy's care, quality, life, and safety. So I'm not trying to revisit 20 years. I'm trying to revisit cases where it's catastrophic and permanent. And I'd like to use Nancy's case to help the future Nancy's and people like myself and my kids that have to take care of them. Thank you.
Thank you so much for sharing. Who's next?
Stuart Nagurka, would you please unmute?
Thank you. I'm Stuart Nagurka, former juror, Arlington County Circuit Court. I support this bill. Our 7-person jury reached a unanimous decision that the doctor was at fault and that his negligence resulted in the patient requiring 24-hour care the rest of her life. After we were dismissed, every juror was stunned when we learned the Commonwealth's cap on medical malpractice liability is preventing this wronged woman from receiving her just award. Sadly, the doctor's insurance company does not have to pay what's owed, and if it isn't paying, who does? We do, because if wrong patients don't have the resources, Medicaid steps in, and it's funded by our tax dollars, bailing out the insurance industry. This bill is an improvement over existing law. It's a change I support. Please change the law. Do your duty. Forget 20-year deals. Legislatures are elected every other year to make new laws. Thank you.
Thank you so much, sir. Okay. Senator Morrissey's got a question.
Senator Servo, if the individual has a med mal case and there are injuries, there are medical expenses, there is treatment, ongoing treatment, et cetera, that goes over in 2022 would be 2.5 million, are they able to recover?
No, not under current law.
All right, so further question.
Senator Morrissey's got another question.
The person is involved in med mal and there are medical expenses that total $5 million. There's future care that costs $5 million. I could go on. Are you saying they are limited for all of those damages to a total of, in this year, 2.55 million?
Right.
Under current law, yes. Under this bill, if you were to pass it and a jury were to find a permanent injury, that wouldn't apply anymore.
There would be no limit.
Right.
Okay. People in opposition, Senator Boysko.
I have a question. So we heard this bill last year, correct? Can you remind us what we agreed would happen? It was going to go to the Boyd Graves Commission. Is that, no?
No, it was a little different last year, but generally the same concept. The details were different, but I thought we agreed it was going to go to civil sub and be looked at over the interim.
Did that happen?
I think that was 2020. Was that 2021?
I don't remember. It was either 2020 or 21, but it was we were going to talk about it in civil sub in the interim, and we never did.
Yeah, I think what if I might, Mr. Chair, we did have a hearing in civil sub. I can't remember if it was 20 or 21, but it was my recommendation that the parties come back with something similar to the birth injury fund, some type of third-party source. I got to be honest, I don't feel bound by an agreement. I do, though, have a problem just undoing the cap at this point, when so much is predicated on it. I do think there ought to be some third-party fund like the birth injury fund to address these situations like Mrs., I didn't catch the last name, Harvey.
Garing, I think.
Yeah, but that's kind of where we were when we last heard this.
Okay, we still got to hear from people that are opposed to the bill, and you've got 2 minutes.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
Senator Serval, there are people behind you wanting to speak.
Sorry.
Mr. Chairman, members of the committee, Scott Johnson, General Counsel for the Medical Society of Virginia. We are opposed to this bill. I want to remind you, this is not the Trial Lawyer Association bill. They honor the 20-year agreement, as does the Medical Society and the Hospital Association. To Senator Boysko's question, last year, this issue was sent to the Boyd Graves Conference. To my understanding, in October, they did not get to take this up. We would ask that you not support this bill or that it go forward. One thing I've committed to Senator Stanley is in the off-season, we're willing to sit down and look at catastrophic cases to see if something can be done in that arena. We do not want to upset the apple cart with where our medical malpractice is, especially right now in the middle of COVID. So with that, Mr. Chairman, on the line, I've got Dr. Brian Hanrahan from the emergency room at Chippenham when it's appropriate time, and I'll hand off now to Steve McCoy.
Well, Dr. Hanrahan is probably just going to be able to identify himself. Please.
Thank you, Mr. Chairman, members of the committee. My name is Steve McCoy. I'm the General Counsel of Patient First Corporation. We provide primary and urgent care services at 78 medical centers in 4 states. 3 of those states are Pennsylvania, Maryland, and New Jersey. They do not have a cap, as Virginia does. And so I wanted to speak to 2 aspects of our experience working in states with and without a cap like this. In states like Pennsylvania, our costs are substantially higher, and they're higher in specific ways. We pay more for insurance. Our insurance rates go up more quickly. And most interestingly, we are sued much more frequently in states like Pennsylvania than we are in Virginia. What's curious about that is the whole purpose of our enterprise is to have a patient first that you go into here in Richmond or in Virginia Beach be the same as it is in Pennsylvania. We have the same facilities, we offer the same services, we have the same staff and the same physicians. Yet with half the number of patients in Pennsylvania, we're sued 4 to 5 times as often as we are in Virginia. It raises our costs across the board. The other thing I'd like to comment on briefly is the difficulty recruiting primary care physicians in states that don't have a cap on medical malpractice liability. We have a much more difficult time getting physicians to come to Pennsylvania and stay there. Thank you very much.
I think we get it. And just please identify yourself and any group you represent.
Mr. Chairman, Christopher West with Kaiser Permanente. We're opposed to the bill.
Mr. Chairman, members of the committee, Brent Rawlings, Virginia Hospital and Healthcare Association, we're opposed.
Mr. Chairman, Andrew Lamar on behalf of the Virginia Nurses Association, also opposed. Thank you very much.
Okay. And we've got some people online. And because we've run over time, you just identify yourself and any group you represent.
Brian Hanrahan, would you please unmute?
Yeah, hi, thanks. My name's Brian Hanrahan. I'm here at Chippenham Johnson Willis Hospital. We oppose this bill. I'm hemorrhaging providers. We can't barely staff our emergency department. This is the last thing we need now. Thank you.
Thank you so much.
Matt Overturf, would you please unmute?
I'm Matt Overturf, the National Association of Mutual Insurance Companies. We are also opposed to the bill.
Okay,
thank you.
Very much. Is there further discussion by the committee? The bill's before you. Do you want to finish up, Senator Stanley or Servell? Or?
How about I move to
Senator
PBI?
Briscoe has a question.
Go ahead.
Is there a question? No. Mr. Chairman, with all the talk you've heard, you'd think our medical system is going to completely fall apart if this has happened. We're only one of 2 states that has a cap like this. And the medical care is not falling apart everywhere else. From my point of view, the only people our existing policy benefits are insurance companies. I actually wasn't prepared to present this today, but when I looked into it last time this came up, I reached out to the Virginia Bureau of Insurance and asked them to compare premiums between Virginia and other states that were uncapped, and they were virtually the same within various subspecialties, which is what tends to drive the rates. And what drives premiums is the bond market. And I'm telling you right now, our courts are full of these cases because there's very little risk of going to trial if you know your damages are capped. So they just roll the dice constantly on these cases, and a lot of them go to trial and clog up the courts. There's a lot of other meritorious cases to be brought, but it ain't worth it because of this cap right now. It's an awful situation. It was an awful deal. I don't consider myself bound by it. I hope we get rid of it.
Senator Morrissey's got a question.
I've got a quick question as Mr. Johnson. I too agree we have to give some deference to decisions that are made by previous General Assembly sessions, but it's not dispositive, and it doesn't mean we can't change it. But help me this. I am the son of a physician. I understand how some people can use the system as a lottery ticket. But explain to me why we would have a cap on a situation where there's med mal and there's no question that the behavior of the physician, it was an accidental, but the behavior of the physician caused an individual to sustain real demonstrative damages totaling $8 million, future care, medical bills, et cetera. Why would what is the rationale to cap it at $2.5 million if there is a real demonstrable, measurable amount of damages far in excess of that?
Mr. Chairman, Senator Morrissey, I would take you back to 1975. And in 1975, probably 3/4 of the medical malpractice insurance in Virginia was written by a company called St. Paul out of Minnesota. And they made the decision that they were going to stop writing insurance in Virginia, stop across the board. And that created a whole lot of panic and imbalance in the market. And so to figure out how you balance public policy to encourage companies to write in Virginia and cover physicians and hospitals, the medical malpractice cap was a product of the General Assembly. And over time, it is increased. Is it perfect? No. But does it create stability? Yes. When you look at this 20-year deal that y'all struck in 2012, it has created stability in the market, so you have multiple carriers wanting to write. Competition drives down cost, and that's where it is.
The bill is before the committee. If you're going to report the bill, the motion is to report and re-refer to finance.
Mr. Chair.
Senator Peterson.
I'll make a motion, and I'm going to make a motion to pass it by with a letter to somebody. And let me state what the issue is. And that is, I do believe victims are not being fully compensated. I do believe they are not having their rights heard. I do believe that we are caught in a system where they're not being fully compensated, and I'm not quite sure who the right payer is. And normally, we would address this at a VTLA convention or with a meeting between VTLA and doctors, but they've already made a deal. And so I would love to convene a work group, but frankly, I don't have the parties in front of me. And I'm not quite sure what to do with it. So I will vote to PBI. It's not that I'm not sympathetic or I don't even agree it's the best policy. It's just, I'm not quite sure where we're going right now.
I think Senator Norman earlier made a motion to PBI. You're making a motion to PBI with a letter. A letter to who? I don't know.
I'll second. I'll second Senator Peterson.
How about the Bureau of Insurance?
Okay.
For anybody.
Okay.
That maybe we can come up with some type of, like I said, birth injury fund.
Okay, with a letter to the Bureau of
Parallel.
Insurance asking for some fund similar, analogous to the birth entry fund.
I
Okay.
second that.
Well, it's
Mr.
already
Chair.
been seconded. It's been thirded by Senator Boysko. So all in favor of that, vote on the electronic voting machine. Okay,
Mr.
we've got,
Chair, I can't, I did. I can't, would you please revoke my proxy?
okay, we've got one bill left and
Excuse me,
Senator
Senator,
Edwards.
Mr. Chair, that's not my vote. I didn't, no, that's not my vote. Oh, okay.
Senator Edwards,
That's 12 notes,
Senate
3.
Resolution 1, it calls for a statewide study of public defenders' offices. Senator Edwards, and this is also, if it's reported, it has to go to finance. Senator Edwards, the one question I had was, you're asking for the study to be done by the Indigent Defense Council, and I don't know whether the Indigent Defense Council could do this work, and I'm just asking whether the Judicial Council would be a better
A good question. Yeah, we have a speaker. Yeah.
Good morning, Mr. Chairman. Maria Jankowski, Virginia Indigent Defense Commission. We will certainly do whatever the General Assembly asks us to do. We've never done a study like this that I'm aware of. Certainly, I would hope we would be an integral part of the study if there is a study done. And we certainly will do it if you ask us to.
Well, here's what I was thinking. The Judicial Council, I think, is the group that studied the Court of Appeals and came up with a better cost estimate. And I didn't know whether the Indigent Defense Commission by itself had the ability to make those sorts of projections.
It would be a lengthy study. We would have to get into the communities. We'd have to have conversations about frequency of how often does JDR meet in Campbell County. We would have to look at where the regional jails are, how far they are, what jails are being utilized by particular communities. And we don't have on our staff sort of the staff that like the Crime Commission has, the social scientists, those type of researchers. But we certainly can look at data, we can look at caseloads, we could do it if you ask us to, but we could also work in tandem with someone else if that was the committee's pleasure. I'm not familiar with whether or not we've ever done a study like this before.
Does Charles or Steve Benjamin have any ideas as to who else would do the study? That's why I put as the commission. I couldn't think of anybody else.
Mr. Chair, I think the other Mr. Chair's idea of something to the Judicial Council is probably appropriate, given the work of the Judicial Council and their study out with the Court of Appeals expansion, they can take a holistic look at the criminal justice defense system to come up with some recommendations to make a statewide coverage of public defenders' offices with the input from the Indigent Defense Commission.
We would
Benjamin?
definitely want to be,
Yeah.
Mr. Chairman, very much involved in it, because we know our staffing, we know our salaries, we know that information.
I'm on the Judicial Council, but I'm not sure they do this. I mean, I don't know. Steve,
They
anybody?
did it with the Court of Appeals.
That was the appellate court, I know that, but we're talking about expanding the Indigent Defense the body, the public defender's offices.
Mr. Chairman, I will also bring to your attention, JLARC did a pretty extensive study in the off-season on juvenile justice, and one of their many, many, many recommendations that came out of that study related to the representation of children in Virginia and the juvenile justice system, and one of their recommendations was a juvenile public defender system that they recommended being at least investigated or explored.
Well, how about this
Mr.
adding?
Qualiato's got something.
Yeah, Mr. Chair, I think JLARC would also be another potential study committee. I do know that JLARC sometimes does have a lot on their plate, but they would also be an appropriate study commission.
Why don't we add both of them?
Mr. Chairman, I will tell you that for almost 700-person agency, we have about 22 people in the administrative offices. We have 5 HR people, 5 IT people. We are very lean, so we don't have a lot of extra staff that don't have already huge responsibilities.
Is this something you think you'd get to if we sent this to JLARC?
Mr. Chairman, members of the committee, Hal Greer from JLARC, we could certainly take this under consideration. The way it works is our commission, if it's not a joint resolution, is our commission decides our work, but a letter could be sent to JLARC, and then this could be considered for a study for us to do going forward.
Could you do it with the Indigent Defense Commission?
We could certainly, I mean, generally our work is not done in collaboration. We do our work separately, but we would certainly fully consider their input in the study that we did.
Well, maybe, Mr. Chair, I might suggest that we would carry this bill over and write a letter to JLARC and ask them to collaborate with the Indigent Defense Commission, the Judicial Council, whomever. You can write the letter. See if it can be done, because I just don't know who else can get the study done that quickly.
I don't either. Charles, got any ideas?
Mr. Chair, I'm almost out of ideas, but I think that a letter to JLARC and/or the Judicial Council, would be appropriate, and hopefully we get back a good study to kind of build some ideas off of.
Okay. Well, then I make a motion that the committee send a letter to JLARC.
Carry over the bill?
And the Judicial Council and the Indigent Defense Commission to look into this? How's that?
Absolutely, Mr. Chairman, and we're happy to look into it. We're happy to work with any organization.
Okay. And with that, move that we carry it over with these letters.
Thank you.
Okay, motion and a second to carry the bill over and send a letter to JLARC, the Judicial Council, and the Indigent Defense Commission to ask them to collaborate on a study to determine what the feasibility of the development of a statewide public defender office. Got that? Any other motions? If not, open the roll. We vote green if that's what you want to do. Okay, with that
That's
bill
15-0.
carried over, with that, the committee will rise.